All rise and be silent. The Honorable Judges of the Intermediate Court of Appeals, Chief Judge Charles O. Lawrence presiding. Oyez, oyez, oyez. Silence is now commanded on penalty of fine or imprisonment while the Honorable Judges of the Intermediate Court of Appeals are now sitting. Let all persons having motions to make and appeals to prosecute come forward, and you shall be heard. God save the state of West Virginia and this honorable court. Please be seated.
I don't have my gavel.
Oh, no.
Oh, no. Welcome, and I wanted to introduce Judge Lovejoy, who's sitting for Judge White, who is disqualified in this matter. And thank you so much, Judge Lovejoy, for sitting with us here for this first case. The clerk will call the first case.
First on the Rule 19 docket, Michael Baker and George Cameron Baker, trustees, Trustee George Cameron Baker and Susan Ann Baker versus Daniel C. Cooper as executor of the estate of George C. Baker. Number 24 ICA 253, an appeal from the Circuit Court of Braxton County. As noted by Chief Judge Lawrenson, Judge Ron White is voluntarily recused, and Judge Chad S. Lovejoy sits by temporary assignment.
Mr. Rogers, you may proceed. We have scheduled, this is Rule 19, but altered the time frame, so you have 15 minutes to present your case. Would you like to reserve any time?
I'll reserve 3 minutes, Your Honor.
Very well. You may proceed.
May it please the court, my name is R. Terrence Rogers. I'm with the law firm of K. Casto and Cheney, PLLC, and I'm here on behalf of petitioners Michael C. Baker and George Cameron Baker as trustees, and George Cameron Baker and Susan Ann Baker as beneficiaries. This appeal basically boils down to two questions. The first question is, was the estate of George C. Baker properly billed reasonable attorney fees by Stephen F. Luby for the work he did for Daniel C. Cooper as executor of the estate, of that estate, for the period of time from Mr. Luby's engagement in 2010 through November 15, 2016? The answer to that question is clearly no. The second question is, what amount of attorney fees is reasonable for the work Mr. Luby did do for that estate? The answer to that question is, based upon the only evidence, which was before the fiduciary supervisor and the county commission, no more than $75,000. The circuit court erred by entering the order that's on appeal here today because it failed to address the fact that most of the legal services Mr. Luby performed were legal services for other entities which he did not represent and for which Mr. Cooper had no authority to authorize him to perform those services, such that the bulk of the attorney fees for those legal services are not reasonable administrative expenses of the estate of George C. Baker. That estate was opened in September of 2009. A little over 6 years later, on November 15, 2016, over $600,000 in attorney fees had been billed to the estate. At that time, no appraisement of the probate assets of the estate had been prepared and filed. That didn't happen until August of 2018. At that time, that is November of 2016, no non-probate inventory for the estate had been prepared and submitted. That didn't happen until August of 2018. At that time, again, November of 2016, no annual estate reports for the estate had been prepared and filed. The first one of those was not prepared and filed until September of 2018. By that time, again, we're talking November of 2016, Mr. Luby had prepared and filed 3 annual estate tax returns for the estate. However, they were not prepared correctly, and an accountant had to be hired and prepare and file corrected annual estate tax returns for those 3 years. Mr. Luby billed the estate just under $35,000 to prepare and file those incorrect annual estate tax returns. The accountant who was hired charged the estate about $8,000 to correct Mr. Luby's mistakes. So by November 2016, when $600,000 had been billed to the estate, none of that stuff had occurred. No federal estate tax return had been prepared and filed. That didn't happen until March of 2020. So what was done for that? Well, what was done was for other estates and trusts, but not for the estate of George C. Baker. Moreover, what was done for those other estates and for those certain trusts was done without any authorization from those other estates and those trusts. Significantly, Mr. Luby had no attorney-client relationship with any of those other estates or any of those trusts, and his only client was Mr. Cooper as the executor of the estate of George C. Baker, as evidenced by the engagement letter, which was not prepared and executed until late 2018, about 8 years after Mr. Luby was first engaged by Mr. Cooper. As our Supreme Court has clearly indicated in Lawyers Disciplinary Board versus Goetschel, I'm not sure I'm pronouncing that correct, but I think that's correct, it is the attorney's burden to establish that his client had agreed that the attorney representation of him and that what the fees would be charged. So there has to be an agreement with the actual client. Here, Mr. Luby never proved that any other of the other estates or any of those other certain trusts ever agreed to him representing them. And Mr. Cooper admits the same on page 18 of his brief when he states that there were no trustees until November 30, 2016, which is 15 days after the last bill, which the cumulative total was $600,000 was submitted to the estate. That same case further provides that the burden of proof is always upon the attorney to show the reasonableness of the fees charged. I want to repeat that. The burden of proof is always upon the attorney to show the reasonableness of the fees charged. Mr. Luby clearly never met that burden of proof. As a matter of fact, Mr. Luby told the county commission when testifying about the bills or invoices he had submitted to the estate to be paid, now this is a quote, "Now people can criticize my entries, and they're right. They were vague." John?
I mean, you're giving us compelling arguments about the reasonableness of these attorneys' fees. Isn't one of the legal questions here when the timing of that should be, whether there's the authority to, based on the supervision statute, to do this at any time through the process, or whether under 44-4 it should wait till the end? I mean, isn't that the legal question we're here to talk about, more so than the specific arguments of the reasonableness of the attorney's fees?
That certainly is a legal question, Your Honor. But I think that at the outset, to answer that question, the Braxton County Commission, by Constitution, had exclusive and broad jurisdiction over the estate of George C. Baker. Next, the court needs to note that the Braxton County Commission has all powers statutorily which are reasonable and necessarily implied to exercise that jurisdiction. That's both in our Constitution and in the statutes. And by statute, the county commission, in this case the Braxton County Commission, is over the Braxton County Supervisor. And West Virginia Code Section 44-3A, capital A, -3, paren, little b, close paren, provides that the fiduciary supervisor here has, quote, general supervision of all fiduciary matters and of all fiduciaries or personal representatives, such as the executor of the estate of George C. Baker. So it's the term there, all, and again, it applies not only to all fiduciary matters, but all fiduciaries, including Mr. Cooper as the executor of this estate. And one of the responsibilities of fiduciary supervisors, by statute, like the fiduciary supervisor here, is to review estate administrative expenses for reasonableness. And that is provided for in West Virginia Code Section 44-4-12. Now, that code section uses the word fiduciary commissioner, but by virtue of the Article 3A of Chapter 44, anything that relates where the word fiduciary commissioner is used, when a county has adopted the fiduciary supervisor system, like Braxton County has, the word supervisor is to be inserted where the word commissioner is. And it's axiomatic that if one has the responsibility to determine what is reasonable, he or she also has the responsibility to determine what is unreasonable. which is something that the county commission clearly recognized in its May 21, 2021 order, and which is, right on point. I mean, it's very succinct how the Braxton County Commission stated that if somebody under statute has a power to determine what's reasonable, he or she also has inherently the power to determine what's unreasonable. And that's what the fiduciary supervisor did here. She determined that $75,000 was reasonable and that $600,000 was unreasonable. Now, Mr. Cooper contended, and unfortunately the circuit court adopted it, that such a determination by the fiduciary super could only be made after the exorbitant $600,000 had been paid by Mr. Cooper to Mr. Luby. That contention by Mr. Cooper and the adoption of that contention by the circuit court, it flies in the face of various provisions of Chapter 44 of the West Virginia Code, 44.1, 14, 44.3A, 3, b, 44.4, 12, 44.3, capital A, 29. Not only does it fly in the face of these statutory provisions, it flies in the face of common sense. I mean, you're going to let the horse out of the barn, you're going to let the $600,000 be paid, and it's clear that this supervisory power this power that the fiduciary supervisor has is not limited till the end of the administration of the estate. I mean, otherwise the terms that are used in the statute wouldn't be there. And again, I think that the county commission in its May 21, 2021 order got it right. And unfortunately, the circuit court got it wrong. I mean, I think that the fiduciary supervisor did have the power to make that determination. The county commission did have the power to affirm that determination by its fiduciary supervisor.
Mr. Rogers, could I ask you on the two statutes you've referenced with Judge Greer, you talked about the general supervision statute 44.3A3 parens B, but there is a specific statute 44.412 that you referenced, which specifically deals with the allowance of reasonable expenses. And it has in the statute the prepositional phrase, in stating and settling the account. Now, as I read it, that would modify the verb or the shall allow. So is that not any kind of a limit or specific instruction on when expenses are reviewed and approved?
Well, it could be argued that, but I think that the statute where the general supervisory powers of the fiduciary supervisors in 44.3A3B would control, because it just doesn't make sense to wait till the end of the case, to wait till a bunch of expenses have been paid by the executor of an estate, and then review them and then try to claw back that money. That makes no sense whatsoever. I think, like I said earlier, and I'm not, at the risk of being repetitive, I think the county commission got it right. I think that, that there's these broad powers that fiduciary supervisors have under 44.3, capital A -3, paren little b, close paren, and I think that that's the power that the fiduciary supervisor acted under and made her determination. And I might add that the county commission effectively in a prior hearing that was on a petition to remove Mr. Cooper as the executor of the estate, the motion, what I'll call the attorney fee motion, had been filed at that point in time, and it came up in the course of that hearing about whether the attorney fee motion was being heard then, and the county commission made it clear, no, we're just hearing the removal petition. The attorney fee motion is for the fiduciary supervisor to make her determination in first, and that's exactly what happened here, and it happened under 44, 3, capital A -3, paren little b, close paren. I don't know, have I answered your question, Your Honor?
Yes, sir.
Okay. Judge Greer, did I answer your question?
Yes, sir.
Okay.
If you want to keep your time, you might want to wrap it up.
I will wrap it up, and I'll keep my time.
Thank you.
Thank you.
Thank you.
Your Honors, I'm Dan Cooper, and seated with me is Steve Luby, and he may have a thing he'd like to add to this argument. But I want to point out this appeal here today is not about the amount of the attorney's fees. You know, I haven't paid any attorney's fees to Mr. Luby's firm yet. And, you know, just by way of how this would have worked if it had worked the way it should have worked, is at the time that Mr. Luby was wrapping up his work for the estate, which would have been, if it worked right, would have been 10, 12 years ago, he would have presented a bill. I would have reviewed the bill. We would have talked about it. We'd have talked about paying the bill, and we'd have come to some agreement on what the amount of the fees should be, and I would have then paid him the money if I had it. I didn't have the money to pay him, and that's why I haven't paid him anything yet, because what's really going on is an attempt to avoid paying by the J.C. Baker Company, the people that own it, an attempt to avoid paying the debt that is owed to the estate that now has grown to something more than $2 million. So everything that they're doing, their entire strategy is embarked upon a rather unexplainable attempt to avoid paying that debt. And so all of this is that, an attempt to avoid paying that debt. The issue isn't the amount of the attorney's fees, but because that's what this appeal is about, and let me talk about that just a little bit. The amount of the attorney's fees is not a ripe issue to be discussing at this point. Why? Because I haven't paid any yet. So the issue's never been properly put before the fiduciary supervisor. Rather, what happened was, just in an attempt to throw a wrench in things, a rather backdoor method was used to get the fiduciary supervisor to enter this order that said, nah, $75,000 is all you could have. Well, that was ridiculous, because that really is ridiculous, because, you know, I want to tell you what he said about that, just so you'll know. Because it wasn't relevant to anything. When he said it, he came into the hearing to have me removed. And Mr. Tweel said, yeah, usually on an estate this size, fees would be about $75,000. Well, have you looked at any of the work that needed to be done in this estate? Nope, not a bit. Have you looked at any bill? Nope, haven't seen a bill. Do you have any idea what was needed? No. So even if we wanted to give Mr. Tweel's testimony about $75,000 any credence at all, it would really be more properly a starting point. You'd say, okay, if you had an estate that there weren't any issues, weren't any odd issues to handle, yeah, $75,000 would be a reasonable fee, according to Mr. Tweel. Well, but what if you had an estate where you had a whole bunch of stuff that you had to do that was unusual, like you did in this one? Well, $75,000 might be where you'd start, and you'd say, okay, how much more than $75,000 do you think we should be paying? But instead, they got essentially the fiduciary supervisor, who was a friend of theirs, by the way, to enter this order that limited the fees on the whole thing to $75,000 without ever having a hearing on what the amount of the fees should be. So the question in this appeal is, was the circuit court properly within its power to set that aside? And the circuit court clearly is properly within its power to set that aside. If the judge looked at that and said what I just told you, that it was got in a backdoor way, it was not based on anything proper, then of course he's going to set it aside. And you know, we have told the judge, and he's even stated from the bench that he agrees with us, that because the ultimate issue here that people seem to want to fight about is the amount of the attorney's fees. If we're ever going to review the amount of the attorney's fees, you're going to have somebody that understands what an attorney's fee should be for something. And so the circuit court, we've told the circuit court, we're going to ask you to take jurisdiction over this matter when the time comes and review this and approve it so the fiduciary supervisor doesn't have to. And he stated from the bench that he intends to do that. So once we get there, if we get past this appeal and we get back there and get the estate wrapped up completely, then that attorney's fee issue will be decided and looked at and approved by the circuit court. So the fiduciary supervisor, who really doesn't know what attorney's fees should be on something complicated, doesn't have to do that, improvidently or not, doesn't have to deal with that. So if I may, right now, if there are questions about the tax issues that the court has, Mr. Luby is here to answer them, and I can surrender the discussion to him.
Yeah. We don't have any questions on tax.
Thank you.
Yeah, let me,
We don't have any questions on the tax issue, so you can sit.
Well, but I'd like to use this time to comment on.
We still have some questions maybe for counsel, so,
Oh, okay.
for Mr. Cooper.
Yes.
The key word that sticks out in my crawl for a court with very limited jurisdiction, we're the Intermediate Court of Appeals. We have jurisdiction over a lot of final orders, and this appears to be a final order, but it does not necessarily be a final order resolving disputes among parties. And the circuit court's order, Judge Asbury said, the review and disallowance of unpaid attorney's fees is not ripe for review by the fiduciary supervisor. We have limits on our jurisdiction specifically on, we are not permitted to take an interlocutory appeal. There was no motion filed in this case to dismiss the case based on the interlocutory nature of the order below, which is ultimately, I guess, the county commission's order. That would have been the initial order that was appealed to the circuit court. The circuit court said it wasn't ripe, and basically vacated, in my view, vacated the two orders by the fiduciary supervisor and by the county commission relating to attorney's fees in the matter, and created a method for those disputes to be resolved. It is my assumption that everything came to a stop once the appeal was filed here, so nothing has proceeded. Is that correct?
That is correct. Everything, well, and I'm not sure that everything had to stop. The collection efforts didn't have to stop, but, once the appeal's filed, you sort of feel like, well, we don't know what's going to happen. So we paused to wait and see that. So you are correct. All that happened was the circuit court set aside the order from the fiduciary supervisor. That's all this is about. That's all this appeal is about. And then I guess the question on appeal, I thought, was, does the court have the power to do that? Did it go outside of its jurisdiction to do that? It did not. I mean, I think that's to me, that's obvious that the circuit court had the power to set this aside. And the whole issue, it's not like it's a final ruling on the amount of attorney's fees. It's not at all. We haven't got there at all yet.
Yeah, my just institutional concern is nobody's raised the interlocutory nature of this appeal. It doesn't resolve the issues as to the parties. It doesn't resolve anything. It simply goes back to square one as a basically remanded back for the processing of the remaining administration of the estate. And I think anything we would do would be close to advisory at this point. In terms of pronouncing the reasonableness of an attorney's fees based upon the record in the case. I have concerns that this appeal might not be one that we can hear. You're before us. It's fully briefed. I think you did a great job on both sides. Did a good job on the briefs. I think we understand the issues. So we don't need to get into the tax issues. It's completely irrelevant for our determination, and we prefer to keep a normal oral argument that way in terms of counsel. Any other questions, colleagues? We understand your case.
Thank you.
Mr. Rogers, you have 2 minutes.
Mr. Cooper indicated that he hadn't paid any bills, but he also, if not directly by implication, indicated he hadn't even reviewed any of the bills. And I don't know how that could possibly be reasonable under anybody's view of how an executor ought to administer an estate. And so I think what the county commission did here in referring the attorney fee motion to the fiduciary supervisor's determination on that attorney fee motion and the county commission's affirmance of the decision or the determination of the fiduciary supervisor was clearly reasonable. I got to, Mr. Cooper, again, we pointed this out in our briefing that there's a lot of stuff in this order that was entered by Judge Asbury that's just not part of the record that was before the county commission, and that's all under Haynes that the circuit court should have considered.
Well, in this case, you've been in front of the Supreme Court of Appeals twice.
Correct.
The circuit court's generically pretty familiar with this because those were both orders of the Circuit Court of Braxton County appealed. Supreme Court, even in the removal case, said it was absolutely appropriate for the circuit court to consider all the other items surrounding, surrounding the administration of the estate. That seems to be what happened here as well, doesn't it?
Well, I would agree with that, but again, with all due respect, Your Honor, I don't agree I think that Haynes still applies. I think you have to, the circuit court needed to review what the county commission reviewed. And so some of those Supreme Court decisions that are being referenced, they weren't reviewed by the county commission. They weren't before the county commission. They weren't before the fiduciary supervisor. So they shouldn't have been taken into account and shouldn't have been included in the circuit court's order. And our Supreme Court has held that a circuit court may adopt one party's proposed order, but only if the findings and conclusions represent that judge's own determination and not some long argument and statements of the successful counsel. Our Supreme Court made it clear that mechanical adoptions of findings proposed by counsel is not acceptable, and that's exactly what happened here. As evidenced by the fact that, I don't know what the glitch was exactly, but there were the same order was basically as one document twice. The circuit court judge didn't even review what was submitted to him enough to realize that it had been submitted twice, to pull one of them off and not submit that. This is nothing more than a mechanical adoption of Mr. Cooper's proposed findings of fact or proposed findings. There really are not any conclusions of law, if you will, and his long argumentative arguments. And if for that reason alone, this order should be overturned and it should be a reversal and the decision of the county commission affirmed by this court.
In what way does the order that's on appeal dispose of either a party or a claim?
Dispose of either a party or claim?
Yeah. We're as my colleague said, we only have jurisdiction over final orders.
Right.
What party or claim?
It resolves the part of the case that deals with the attorney fees that were submitted by Mr. Luby to this estate for the period of time from when he was first retained in 2010 through November 15, 2016. It resolved that. I mean, if Mr. Cooper had not first appealed the determination of the fiduciary supervisor and then appealed the determination of the county commission, which affirmed that to the circuit court, that issue would be decided. That issue of what the attorney fees should be for that period of time.
Is an issue the same thing as a claim? My struggle here is I don't see anything in this case is disposed of. There may be an issue that's resolved. We don't get to hear issues.
Well,
we get to hear cases when claims or parties are finalized. And so I'm seeking to identify what the claim or party that's finalized is.
And I don't disagree with Your Honor, except for this is different. This is the administration of an estate. This isn't a civil action where claims are
Well, then maybe we don't have jurisdiction until the whole administration's done.
Well, I disagree with that, Your Honor.
Yeah, well, okay, and that's fine. Explain to me why, under our statutes and our jurisdiction, not just because I think it should be, but help me out under our jurisdiction.
Because you had a determination first by the fiduciary supervisor. Mr. Cooper, as was his right, appealed that to the county commission. The county commission then affirmed the decision of the determination of the fiduciary supervisor. Mr. Cooper then appealed that to the Circuit Court of Braxton County, West Virginia. And so once the Circuit Court of Braxton County, West Virginia reversed the county commission's order, the only recourse that my clients, the petitioners, had was to appeal to this court. That's the only recourse it had. They had, I should say.
Your time has expired. Appreciate it. Thank you so much. The case will be submitted.
All right, remain standing while the judges leave the room. This court will recess until and be silent. This court is again in session. Please be seated.
Clerk will call the next case.
First on the Rule 20 docket, the consolidated cases of Lillie Junkins in her official capacity as Vice Mayor, City of Clarksburg versus West Virginia Ethics Commission, number 24 ICA 486, an appeal from the West Virginia Ethics Commission, and James E. Marino, former mayor of the City of Clarksburg versus West Virginia Ethics Commission, an appeal from the West Virginia Ethics Commission.
Thank you. This is a Rule 20 case, so petitioner's counsel may arise, and you got let me know how much time you'd like to reserve out of that 20 minutes.
Your Honor, I'm going to start by reserving 5 minutes, if I may, please.
I'll do the same.
Well, you don't get an opportunity to do that. You get to use your 20 minutes, and he gets the last word. Petitioner gets first and last.
I thought so.
Yeah, it's all right. Good try, though. You may proceed, sir.
Your Honor, thank you. My name is Ed Rolla. I'm an attorney out of Morgantown. My clients are Lillie Junkins and Jim Marino, and they're both sitting in the second to last row. They came here today because this case is very important to them. We think it's a very important case, and the court can make a very bold statement by permitting for the first time safe harbor for city council members like Ms. Junkins and Mr. Marino. We raised two assignments of error. The main one is that we need to have safe harbor for city council members like Ms. Junkins and Mr. Marino, who rely in good faith upon city attorneys in making decisions that on their face don't appear to be problematic, unethical, or against the law. So by way of background, Ms. Junkins and Mr. Marino were elected as city council members in Clarksburg in 2019. They had a 4-year term that would have gone to 2023. At that time, city council elections and city elections were held on odd-numbered years, and they weren't synced or aligned with the federal and state elections, which were on even-numbered years. So around 2020 and 2021, the city council decided to sync the elections for the city with the state and federal governments for the purposes of increasing voter turnout. So it was a two-step process. The first thing that the city council had to do was have an ordinance prepared. And all that ordinance did was to agree to place on the next ballot an proposed amendment to the city charter, because it's the city charter that sets up the election days. So the city attorney prepared two documents, the ordinance and the proposed charter amendment. The problem, to the extent there was a problem, but the issue, I'll say, not necessarily the problem, was that if the charter amendment was passed by the residents of Clarksburg, the 2023 election date went to 2024, and that created a 1-year gap for those who had terms that expired in 2023. And what the city, through its city attorney, its city manager, its clerk, the city council decided to do with respect to the charter amendment was to have the three individuals, that includes Ms. Junkins and Mr. Marino, have their 3 terms extend 1 year. Now, it wasn't the ordinance that extended the term. The ordinance was structural, it was ministerial, it was procedural. The ordinance did nothing more than allowed the charter amendment to be placed on the ballot. And so what ended up happening in 2021 was that the citizens, decided to adopt the charter amendment. As contemplated by the charter amendment, Ms. Junkins, Mr. Marino, and a third city council member's terms would extend to 2024. Now, we're still in, I believe, 2021 at the time, so those extensions never happened. While they were considering this charter amendment, the city attorney said it would be no problem for this particular charter amendment to take place. It wouldn't be unethical, wouldn't be in violation of any governmental ethics law or statute, rule, or regulation, because it was the people of the city of Clarksburg that would decide if the charter amendment would be enacted. And it was not the ordinance that extended the term, it was the charter amendment that extended the term. And for that reason, the city attorney opined and advised the city council that there were no ethical considerations.
Did the city attorney draft the ordinance?
He did. In the charter amendment. Mr. Marino is a businessman, Ms. Junkins is a teacher. They didn't draft the ordinance and they didn't draft the charter amendment. They relied upon the experts to do that. There might have been, and I have to check the record, there might have been some input from the city manager. There might have been some input from the city clerk, but the whole process was spearheaded by his own admission at the hearing before the ALJ, the attorney that was representing the city. By his own admission, he spearheaded and shepherded the entire process and specifically told the city council, including Mr. Marino, Ms. Junkins, that they could vote on the ordinance.
Just to be clear, what time frame are you saying that occurred, that he specifically told them they could vote on the ordinance?
It would have been prior to the vote, and if they'll give me 1 second, I do have the time frame.
Prior to which vote?
The vote of the ordinance that put the amendment to the city charter on the ballot for the next
Which
city
time,
election.
21 or 23?
This is 2021. There's two. 2021 was the first. 2021 is when they extended. 2023 is the next charter amendment. So there was some question.
You're telling me in the record, there's evidence of your clients receiving advice of counsel prior to the 21 vote?
I believe it's in my petition for appeal that the city attorney said at all times he had told all parties that there would be no issues, because recall, Judge, it wasn't until 2023 that they somewhat pivoted and had a different charter amendment where the 3 extended one-year terms from 2023 up until 2024, the new election date, there would be a new election in 2023 for 3 one-year terms. The city attorney was clear on the record that he advised Marino and Junkins that they could vote without any ethical implications. But if I could, respectfully, that's still irrelevant because it's the city attorney who's supposed to safeguard any ethical questions. And if the city attorney tells them they can vote, then he specifically tells them they can vote. If he doesn't tell them that they can vote, then they're to assume that they can vote. But everything is done by the advice of the city attorney who shepherded the entire process. Our first assignment of error was that there was no gain by Ms. Junkins or Mr. Marino as part of the ordinance vote, because the ordinance didn't extend their term. And to the extent that this falls in some kind of gray area with the ethics statute in terms of receiving a gain from making a vote in office, then that ambiguity should be resolved in favor of Mr. Marino and Ms. Junkins. But the bigger issue is the safe harbor. And we should have a safe harbor for our council members. Many, many other states have provided safe harbor for council members and other public entities and public employees. In Virginia, I've cited the case Harkey versus VDOC. A plaintiff must demonstrate more than the letter of the law was violated. He must show the spirit or the substance of the law was violated. Courts have declined to extend civil penalties even when a public body violated FOIA when it was determined that the public body acted in good faith with advice of counsel. Holding that reliance on the erroneous advice of counsel demonstrated a lack of a knowing and willful violation. In Massachusetts, it shall be a defense to the imposition of a penalty that the public body, after full disclosure, acted in good faith compliance with the advice of the public body's legal counsel. Oregon says the same thing. We do not believe that local officials should be required to make complex decisions regarding expenditures of public funds without the advice of counsel and at their own risk. Such a requirement would discourage competent individuals from seeking or accepting such positions and would be a detriment to local government. Another state, Nevada. Good faith reliance on the advice of counsel retained by a public officer or employee's public body can provide safe harbor protections from a willful violation pursuant to their ethics statutes. New Jersey, same thing. Time Oil Company, which was a Ninth Circuit case, same thing. The Seventh Circuit, same thing, but I'd like the court to consider this because I think it makes an appropriate model for this court to follow. To establish an advice of counsel defense, a defendant must show that before taking action, he in good faith sought the advice of an attorney whom he considered competent for the purpose of securing advice on the lawfulness of his possible future conduct and made a full and accurate report to his attorney of all material facts which the defendant knew and acted strictly in accordance with the advice of his attorney who had been given a full report.
So you take issue with the Ethics Commission's brief at page 8, which says that your client did not present any evidence that, in this case, Ms. Junkins, that she asked the city's attorney or any attorney whether it violated the Ethics Act for her to vote on measures uniquely affecting her. You're disputing that fact assertion that's in the brief?
Say that again, please, Your Honor. I'm sorry.
Sorry, in their brief, the Ethics Commission states that your client did not present any evidence at the hearing that she asked the city's attorney or any attorney whether it violated the West Virginia Ethics Act for her to vote on measures uniquely affecting her. Is that just super parsed? The attorney offered that? Or, I mean, is there some, how did she get and this is with respect to the 2021 votes?
Right, yeah. So if I don't have the brief in front of me, and I don't have page 8 in front of me.
It makes reference to the record, and I didn't.
Right, and if I recall correctly, I think the issue that we had with the administrative law judge finding that there was no evidence presented was that Mr. Marino and Ms. Junkins both were pro se at the hearing before the administrative law judge. The administrative law judge had indicated that they presented no evidence. We took issue with that because they clearly made statements, opening statements, they made closing arguments, and they asked questions as pro se litigants. They asked questions in such a way that it was very clear what their positions were. In other words, Mr. Marsh, their attorney, the city attorney, was asked the question, isn't it true that you told us that there would be no problems with voting for these ordinances as it relates to these charter amendments? Answer, yes. Well, isn't it true that you told us that you could defend us? Answer, yes. So although they didn't present by way of their own testimony when time to testify their own evidence in a way that you and I and other attorneys would have evidence presented, they were clear in their openings, they were clear in their closings, they were clear in the ways that they pulled information out of the witnesses, what their positions were. I think they should have been given a little bit of leeway instead of stating that they provided no evidence or testimony.
Did they want counsel at that hearing?
I had a conflict. I had been counseling them sort of behind the scenes. They certainly had the right to have counsel, but they decided that they would represent themselves.
So they didn't make an issue of not having counsel?
No, I don't think they made an issue. But I think they're clear from their openings, their closings, and their questions, and the information they did solicit. There is no dispute that the person that should have been safeguarding this entire process, if there was a problem, I actually don't think there was a problem with them voting on the ordinances for the reasons that we stated in our first assignment of error, which was they didn't get a benefit from the vote on the ordinance because any benefit would have been obtained from the city. Now, of course, they reversed it, and they never got that extra year as the charter amendment that the city residents of Clarksburg endorsed and agreed to. They never got that year because they changed course, and the city council had another charter amendment which put those 3 one-year terms up for election. So they did end in 2023 as they originally were supposed to, even though the next election date was going to be 2024. But if I could, and I think I've got a couple minutes before got 1 minute before I think I need to step aside, and I'll do that real quick. I think city council members need to have a safe harbor. In fact, to tell you what, I'm going to go and use my time if I could. Is that all right?
Sure.
My last 2 minutes. There needs to be a safe harbor. Because if we were to tell Mr. Marino and Ms. Junkins what should they have done differently based upon what they know now? What are we going to tell them? How do we guide the actions of city council members when they get this decision? If the ethics committee's decision is upheld, what are we going to tell future council members on how to guide their actions? We're going to tell them you can't listen to your city attorney. Or if you do listen to the city attorney, a competent city attorney from a good firm, if you do listen and for some reason the ethics commission disagrees, not the city attorneys. City attorneys aren't on the hook. No one went after the city attorney. No one went after the city clerk. No one went after the city manager. They went after these two people. And they're the ones that got the public reprimand. And they're the ones that got the fine. And they're the ones that got the court cost ordered to pay. So what will this decision, if we uphold the ethics committee decision, and I'm asking this rhetorically, I'm not asking for an answer, what are we telling city council members that they should do if they're confronted with the same situation, where what they're looking at is an ordinance where they don't think they have a problem, and the city attorney tells them you don't have a problem, and the city manager and the city clerk don't flag a problem? Are they supposed to hire their own attorney? That wouldn't matter because we can't rely upon our own counsel, just like we can't rely upon the city attorney. So there needs to be a safe harbor. It's patently unfair for Mr. Marino and Ms. Junkins to be told that you need to have a public reprimand and we need to fine you because they did nothing wrong. That's our position. Thank you.
May it please the court. My name is John Roush. I'm employed by the West Virginia Ethics Commission, but in a way I represent the people of West Virginia. Essentially, I want to make a few corrections here, a few rebuttals or responses. The hearing examiner who was hired and had a evidentiary hearing determined that there was no evidence that there was any advice of counsel before the 2021 votes. Now, I say 3, but I don't want to confuse the matter. Of these 2 individuals, one of them went and participated in 2 votes and was absent for the other one. The other one missed one of the other votes, but there were 2 each. Basically, if you will look at our brief, basically not at page 8, but page 13, it relates to what Mr. Marsh, the Clarksburg attorney, said with regard to discussing the Ethics Act. And he indicated that sometime between the first and second vote on the ordinance in 2023, that he had a discussion and indicated that, if I understand his testimony, I wasn't there, but I read it several times. But in any event, that basically that it was problematic. They might consider voting or recusing themselves, but that he thought that the situation could be defended before the Ethics Commission. So that was between the first and the second vote in 2023. There's no indication that they got any sort of advice, sought the advice, relayed everything that they had to say about the situation, and followed the advice, basically, in 2021. That's what the hearing examiner said, and I mentioned basically that the findings of fact of a hearing examiner and of the commission have to be given great weight unless they're clearly wrong. Second thing I wanted to do here is my opponent is asking for one safe harbor. He's actually trying to sneak a second safe harbor too. His clients chose not to testify at their own evidentiary hearing. They didn't take the oath, they didn't submit themselves to cross-examination, and now we're supposed to give them leeway and believe what they had to say, having done that not under oath.
Was it explained to them that them not testifying could be used against them? Because you're trying to use that against them, are you not?
Well, I'm trying to use basically the fact that anything that they said there when they weren't under oath and subject to cross-examination should be disregarded. Like I say, I'm sure.
It's a question. Was it explained to them that their testimony could be them not testifying could be used against them?
The administrative law judge, my recollection in every hearing, and I believe this one is correct, basically did indicate basically that they had the right to testify or not, basically. And I'm not trying to say that they're guilty because they didn't testify. I'm just saying If I refuse to take the oath, refuse to subject myself to cross-examination, I oughtn't to be able to say whatever I want to, and then that be treated as sworn testimony. Getting back to my main point, though, with regard to the safe harbor for relying upon the advice of counsel, our Supreme Court, I know my opponent has was quoted a bunch of cases from other jurisdiction, has said that basically that is a per se defense when the case is a case of malicious prosecution. In other matters, it can be taken in mitigation or looked at as for the good faith. There's no indication in the state of West Virginia under the case of Godwin that Powers Godwin versus Godwin, that reliance on the advice of counsel is a complete defense, basically. It's just mitigation. And in fact, that was done. If you remember, the administrative law judge gave a fine of quite a bit higher than what the commission actually determined. I think he had recommended a $2,300 fine for each of these individuals. That was reduced to $200. I suspect on that basis, basically, upon the reliance of individuals on counsel. Now,
Counsel, does the code say that one is prohibited from voting on whether the people should be given an opportunity to extend the term of an official? Does the code say that?
Actually, the code indicates, and that's 6B-2-5 subsection J, that an individual may not vote at all, whether they vote for or against or on any matter in which they have a financial interest. And these two individuals had a financial interest. City council members are paid $2,000 if they're just a council person, $2,500 if they're a vice mayor, $3,000 a year if they're mayor, and they also get
But
insurance.
the vote did not make it effective, did it?
Well, as the hearing examiner said, if they had not voted to put that proposition before the public, then there could not have been any change in the charter. There could not have been any change. The ordinance couldn't have been passed, basically.
So you're reading that statute liberally in order to get to your.
If you're asking me if there are
Correct.
any statute that says that you can't act to extend a person's term while they're in office, as I indicated in my brief, there's a section in Chapter 8 that relates to that, and there's also a constitutional provision that you can't increase the compensation of anyone after their term has already started, basically. We're just dealing with the voting act, the voting portions of the Ethics Act. But yes, it says that you can't, essentially, they weren't found guilty of extending their own terms. They were found guilty of voting on a matter in which they had a financial interest. And it's our contention that voting to put it before the public, where the public can vote it up or down, is essentially taking an action, voting on a measure of which you have a financial interest.
So in your brief, you state that 61-10-15, which isn't implicated here, should be construed to protect the public from mistake as well as contrivance. But you say we should have the same thing with the sections that we're talking about. How's the application of this section and the way the Ethics Commission has applied it protecting the public when the public actually voted on the increase in the term?
Well, they didn't vote on somebody having their term extended, or excuse me, they voted on having someone's person extended. They did not have a real vote where they voted who was going to represent them for that next year. We believe that is a requirement. If they didn't vote and put it before the people, they wouldn't have that opportunity.
I mean,
and with regard to 60,
so with respect to that, what if a public official, after they had filed and gone through a primary, and there's no one in the general election that was that's running against them in the general election? What if they, after that point, pass an ordinance which increases their compensation? Is that a violation of the Ethics Act?
Actually, I'm not certain that would be, because you indicated this occurs before the election, although they're unimposed, because one, they could die, two, there could be a write-in campaign where somebody would be put in the office, or they're not guaranteed that office. So I don't believe that would be a violation of West Virginia Ethics Act.
Well, aren't they more culpable, though? Because they know they're going to be basically in office?
Well, they're not certain. Isn't that essentially what, and I'm not disparaging the two, two individuals here, the city councilmen, but isn't that essentially what they're doing? I mean, if they extended the office, they knew they were going to continue in that.
But the people voted on it. That's what you're saying, that in my situation, that the vote of the people basically abstains them from what they did, from the person who did it after they know they're going to be the officer.
Mm-hmm.
You're saying that vote basically makes it so that what they did makes it okay.
Mm-hmm.
They're in the same position. I agree with you. What's the difference?
Well, the difference here, perhaps one thing that'd be a difference, you'd have to be in office already in order to vote to increase your compensation. So I'm assuming you're talking about someone who's running for reelection.
Yes.
Maybe I'm wrong with regard to whether that person is voting to increase their compensation when they don't have a 100% chance of winning, but a 99.99% chance of winning. Perhaps I'm wrong upon that. It is clear that the statute says that if you have a financial interest in a matter, you are not supposed to vote. You are not supposed to stay in the room. You're supposed to abstain. It doesn't say you're not supposed to vote in your financial interest. It says you're supposed to get up, leave, make the person who's keeping the minutes indicate that I'm leaving. I'm leaving here, and I'm recusing myself not only from the vote but from the discussion. And they didn't do that.
So let's move on to the 2023. I'm a little bit, it's a different issue, right? So the 2021, I can see how there's a financial interest, and that's clear, right? Because they're voting to increase their term, but despite the fact that the people then later voted on it. Let's put that aside. The 2023, it's more of a, I guess you're taking the position that 2023, because that 2023 vote is a vote to rescind what was done in 2021, correct?
Well, the 221 vote was about whether they were voting to put a measure for the people to extend their terms without another election.
Yes.
The 2023 votes were their vote to whether that would be undone, right? And they still had an interest. They had an interest in extending their terms by 1 year by voting against those provisions. And in fact, they did vote against those provisions. They voted against the ones to extend their terms in 2021, and then in 2023, they voted against the rescission of that extension of their terms.
So now you're expanding it to actually undoing something that they already have, correct?
Well, in both cases, they have a financial interest.
Yeah,
And under subsection J, no ifs, ands, and buts, and ever. If you have a financial interest, which they clearly do, you're not supposed to vote. It doesn't say you can't vote for your financial interest. You have to vote against it. It says you don't vote. You don't participate in discussion. And they did all of these.
So what if a council member in a different city decides to say, hey, I don't think we deserve any compensation whatsoever. I want to make effective immediately.
Mm-hmm.
Does that mean that no one on city council can vote on that? Because that's a financial interest.
Well, in other words, if you're voting on whether or not to reduce my salary from whatever it is to absolutely zilch, you're correct. That would be. I mean, these people can obviously refuse their salary. But yes, that is something that basically, and I believe the statute prohibits that too. It says that a person can't have after their term started, they can't have their income, their salary increased or decreased, basically. So I would like, if I could, basically, to speak on this safe harbor of having, essentially being able to consult an attorney and basically being, what's the word I'm looking for, have a get-out-of-jail-free card, so to speak. And that is essentially, basically, that's not what the Supreme Court has said. And if you allow that, that will be a safe harbor, but does that mean that anyone can find an attorney who will tell them what they want, and then they can do it? And how likely is that person to file any sort of complaint about an attorney giving them bad advice if that bad advice allowed them to do what they want and to escape the consequences of doing what they want? You talk about safe harbor being a nice thing, what about the people of West Virginia? Won't that really basically drive a hole big enough to drive a truck through the Ethics Commission Act? If anything is okay as long as you consult with an attorney, and they said it was okay. Basically, I think that would be very bad policy. That would, in fact, hurt the Ethics Act, and it would make it very difficult to enforce it.
Do you have anything further?
I got one more question. Does reliance on counsel advice require due diligence on the part of the petitioners? Must they investigate further or get a second opinion?
And the case basically indicated there's several things you have to do. I don't think it requires you to get a second opinion. It means you have to go to the attorney, you have to honestly tell them everything, all the circumstances. You have to be told that what you're asking about is legal to take this conduct, and then you need to follow that advice. I don't believe that there is a requirement. But if you're relating to the question that my opponent asked about what are these people supposed to do if they can't rely upon the city attorney? Well, if you face some significant liability, I think getting an attorney who has your own interest at heart is actually a good thing. The other thing you could possibly do is you could call the Ethics Commission and ask whether this action would be potentially harmful. In fact, a city council did do that in almost exact circumstances that we had in Clarksburg in 2010. An advisory opinion was issued and is published on our site and is available everywhere, which indicates that extending the terms like they proposed then and was actually done in Clarksburg does in fact violate the Ethics Act, and advising them to do essentially what the city of Clarksburg ultimately did, and that is have one-year terms for several of the council positions to bring things back in sync with the four-year cycle.
So are you saying that the attorney Marsh on the 2021 vote didn't know everything that needed to be known in order to tell them to go ahead and proceed to vote? Is that what you're saying?
With regard to the 2021.
Yeah, is there something that Marsh could have known that would have helped Marsh make a more clear decision, given the fact that he made pretty much the decision on the 2023 case? Is there something else that he should have known?
And there's nothing in the 2021 record that I can see that indicates that Mr. Marsh was asked or gave legal advice before the 2021 votes. They were during the 2023 votes.
But I'm asking, is there anything else he could have known that you think that the petitioners should have told him that would have helped him tell them not to vote? Is there anything?
In 2023, the complaints had already been filed about the 2021 votes, so they actually had an ethics complaint pending against them when they took those 2023 votes. If you're asking me, is there anything else that Mr. Marsh should have known to tell them, I certainly wouldn't agree with the advice he gave them, but as far as the factual situation, I'm sure he was involved in it and knew it.
Okay, so he knew everything he needed.
At that point, yes. Thank you.
Thank you. We understand your case. Well, Mr. Roll, you do have some time, and my colleague would like to ask you questions, so please.
Yeah, I want to see how much of a factual dispute we have here. The representation has been made that there's no evidence in the record of actual consultation and an opinion by an attorney prior to 2023. In their brief, they cite specific pages to the record. So my question to you is, can you point me to some place in the record where there's evidence of the city attorney telling your clients, hey, this is not an ethical problem in 21, please, you can go ahead and vote, and it's not an ethics issue problem?
So Judge Greer, you were my first note because I wanted to, you asked me that question the first time I was up. But then I heard Attorney Roush say what he said about his recollection of the facts. And I wanted to let you know, I might be wrong about the discussion that Mr. Marsh had with City Council 2021. It might just have, I might have read the transcript wrong in his testimony wrong. Fair enough. It might have been that in 2021, he prepared the ordinance, he prepared the charter amendment, and simply said, go ahead and vote, without saying there might be implications.
That's
because
fair
as I heard
enough.
Mr.
That's
Roush, he's not going to make a misrepresentation. And I was not making intentional misrepresentation. I might have just got it wrong.
I understand, no problem.
Okay, sorry
Thank you.
about that.
Thank you very much.
And I think, as we talked about, as Attorney Rouse talked about, the complaint coming up, and I think I did mention there was an issue. That's probably, and I'm guessing now, because I don't have a recollection of exactly what happened with respect to the representations, and that's what I'm telling you. Probably, when the issue came up, that's when he said, I can defend this, you guys are okay voting.
That's fine, thank you.
But as I indicated the first time, and I won't belabor this point, I don't know that it affects our safe harbor argument. Because in the second case, the attorney affirmatively says, you can do this. In the first case, if my now understanding is correct as to what Attorney Marsh did, he implicitly said, you can do this. Guys, here's the ordinance, here's the charter amendment, go ahead and vote on it. And they took the advice of counsel because they weren't told otherwise that it was going to implicate any issues. Second, Powers versus Goodwin. You know, back in 1984, when this case came out, and by the way, it was a 3-2 decision, it was not unanimous, the Supreme Court said this advice of counsel issue was unique, and there really hasn't been that much development on the advice of counsel. It does say for malicious prosecution that advice of counsel could be an absolute defense. It doesn't say it always is, it may be. And with respect to other cases, it is said that it is generally held that reliance on advice of counsel is not an absolute defense to charges that a person is acting unlawfully or negligently. And so I would say, yeah, generally that's the rule. In this particular case, there should be safe harbor with advice of counsel. And I'm not convinced that the term absolute defense means that if something's not an absolute defense, that it still cannot absolve you of liability if the other facts and circumstances would suggest that it would be reasonable to absolve you of liability for advice of counsel. In fact, if you recall in Powers versus Goodwin, there was a lot of discussion about how perhaps the two individuals to whom they're referring perhaps didn't act in good faith. The bill in question, they didn't look at closely. They didn't see if the amount was reasonable. The term, I think the times that the bills applied to might not have been consistent with the times that they should have applied to. So there were issues with the bill according to that Supreme Court decision that was an issue, that invoice. And in this case, there's no issues in terms of either Junkins or Mr. Marino thinking that there might be an issue. Two more quick points. This idea, and Judge White, you had asked some questions of Attorney Roush about, you at least observed in your questioning that the ordinance didn't extend the terms, and the ordinance didn't extend the terms. And I'm afraid that if we adopt this definition that anytime there's a financial benefit, anytime a vote gives you a financial benefit, when it's unclear or it's indirect like it is here, we're going down a steep, slippery slope. So if Mr. Marino and Ms. Junkins had, as part of their city council votes, had agreed to expend monies for a Fairmont or Clarksburg City, a city fair, and then Mr. Marino's selling popcorn and Ms. Junkins is selling cotton candy, well, they had a financial benefit for voting for the city fair. Not until we get all the way to the city fair, but the argument, if you buy Attorney Roush's argument, well, they did have a financial interest because they knew that they were going to sell popcorn and candy. What about if they had voted on putting out to bid a lot to be paved? And then someone from Mr. Marino's family decided to put a bid. But the bid would have to be accepted. It would have to be the low bid. It would have to be a qualified bid. Could it be said that Mr. Marino, by allowing a city lot to be put out to bid for a paving project, that he somehow or his family members somehow had a financial interest? And I think that's the slippery slope that we're going
We're going
down.
to need to wrap it up here.
15 seconds, safe harbor. Attorney Rouse says it's going to be a big, wide hole that you could drive a truck through. States all over the nation have adopted safe harbors for just this set of circumstances. They've all done it, not all. That's an exaggeration. I haven't found one that hasn't, and the federal courts also seem to adopt. The Seventh Circuit has adopted safe harbor. So it's not so uncommon that it would be bad for policy. in West Virginia, I think it would be good for policy, and a lot of other states believe so too. Thank you.
Understand your case will be submitted. Thank you.
All rise, remain standing while the judge leaves the room. Court will recess until 11:17. This court is again in session. Please be seated.
Clerk will call the next case, please.
Next on the Rule 19 docket, Central Mutual Insurance Company versus G&G Builders, Inc., number 25 ICA 111, an appeal from the Circuit Court of Cabell County.
You have 10 minutes for this first.
Your Honor, I would like to reserve 4 of those 10 minutes for rebuttal.
Okay.
Good morning, Your Honors. My name is Michael Schultz, and I represent the appellant in this matter, Central Mutual Insurance Company. Central Mutual asked this court to reverse the Circuit Court of Cabell County's order that granted G&G's motion for summary judgment and denied Central Mutual's motion for summary judgment on the insurance coverage issue. Specifically, Central asked that this court reverse the Circuit Court's order to the extent that the Circuit Court failed to find that G&G did not provide timely notice to Central of the Lawson's claims against it as a result of work performed by Stone by Lynch, which was a necessary precedent to coverage under the Central policy. There are 2 basic issues in this appeal. Number 1, did the Circuit Court err when it determined that Central was stopped from relying on the notice provision in the policy? The answer to that one is yes. The Circuit Court erred in 2 ways. Number 1, it erred by failing to follow what it correctly cited to in the Marlin case. And it also erred when it, for some reason, extended the law concerning exclusions under an insurance policy to include something called any limitations. The second issue before this court is whether the Circuit Court erred when it found that an uncontested 5-year delay in providing notice to Central Mutual for the claims asserted by the Lawsons was unreasonable. And the answer to that question is yes, absolutely, the Circuit Court erred. Importantly, Your Honors, there are 2 issues that are not on appeal before this court. Number 1, whether coverage existed under the Central policy for the Lawsons' claims against G&G for work performed by Stone by Lynch. That's not on appeal because there is and was coverage, clearly, and it was conceded by Central from the get-go. The actual issue is whether G&G met a condition precedent to getting that coverage. And that's important to remember that distinction. Coverage isn't an issue. Condition precedent to get that coverage is what's an issue. The second thing not at issue is when the notice period started. The Circuit Court found that the notice period started on June 12th, 2014, when G&G first received notice in the Lawson's counterclaim that the work of Stone by Lynch was claimed by the Lawsons to have damaged them. G&G spends a lot of time in their brief and a lot of effort trying to recast the notice period. But that finding by the Circuit Court was never appealed by G&G, and this court should take that date as set in stone as when the notice period started. Your Honor, the Circuit Court erred when it concluded that Central was stopped from relying upon the notice provision in the policy in 2 ways. Number 1, it misapplied Marlin. The general rule is that principles of waiver and estoppel cannot extend or expand coverage under a policy. There's an exception to that general rule, and Marlin examined one of those exceptions, which is the only one that's before this court. That exception is if there is a misrepresentation in a certificate of insurance at the time that the certificate of insurance was issued, which was detrimentally relied upon by the insured. Circuit Court quoted it right, but then it failed to identify any misrepresentation in the Central certificate of insurance at the time of issuance. Without that misrepresentation, there can't be a detrimental reliance, which is what was required in Marlin. Without a misrepresentation, detrimental reliance, of course, then estoppel doesn't apply. The Circuit Court compounded that error by taking law concerning exclusions and how they have to be conspicuous within the policy before you apply them against an insured, and extended it to something called any limitations, and concluded that any limitations in the policy, such as a notice provision, has to be on the certificate of insurance. Your Honor, a notice provision is not an exclusion at all. An exclusion is a term of art in insurance law. Limitations, literally, the entire policy is a limitation. The insuring agreement is a limitation. If a claim doesn't fall within the insuring agreement, there's no coverage. So if you follow it to its logical conclusion, what the circuit court said is that everything in the policy, which acts as a limitation, has to be in the certificate of insurance, completely upending basic insurance law.
Counsel, the SBL was defended and indemnified, is that correct?
SBL was, yes.
And
Stone by Lynch was defended and indemnified by Cincinnati Insurance Company.
and when did SBL provide notice to G&G Builders?
Your Honor, do not know when SBL provided notice to G&G. What I can tell you, however, is that G&G knew that Stone by Lynch was on the property in 2011 to 2013, performing the work.
I mean, no. When did SBL provide notice to Central? I'm sorry.
Stone by Lynch never provided notice of the claims in the lawsuit to Central.
They never
Never.
did.
Never did.
Then why is why are we talking? Then why is SBL defending and indemnifying SBL, or why is Central defending and indemnifying SBL if they never provided notice?
Central never provided a defense to Stone by Lynch. That defense was provided by Cincinnati Insurance Company. And that's where the dates become important, because Stone by Lynch began work at the property on May 5th, 2011.
Okay, so you're saying Stone by Lynch never, but they ended up paying money, right?
Cincinnati Insurance Company defended Stone by Lynch, and by extension, defended G&G by contributing to G&G's defense based upon work performed by Stone by Lynch. But the important date for that is July 8th, 2011, because Central had the coverage up until that date. Cincinnati Insurance had it beyond that. Cincinnati Insurance fully defended Stone by Lynch and paid the bulk of the indemnity.
So Central didn't pay any money in this at all?
Central paid a portion of the indemnity payment that was a payment made to the Lawsons to settle the claims against both Stone by Lynch and G&G attributed to the work of Stone by Lynch. Yes, Central did pay a part of that indemnity.
Okay, so I guess my question is, why, if Stone by Lynch never gave a notice to Central, then why are they paying money to Central, or why is Central paying money on behalf of SBL? Well, I mean, isn't that when they have also not complied with
Your
the
Honor,
notice?
With all due respect, that inquiry is irrelevant. What's relevant, and this is really for the next appeal, is that there was a full indemnification and a full defense of G&G.
I know you're about out of time, but I want to get to the other issue of notice. And my question to you simply is, both you and your other party want us to rule as a matter of law that the notice is either reasonable or unreasonable. Why don't we default to the general rule that reasonableness of notice is a question for the trier of fact?
Because West Virginia law specifically allows for a court to determine reasonableness without submission to the trial of fact, or to the finder of
That's not the
fact.
general rule. I mean, the general rule is it goes to the trier of fact, and only when the facts and the inferences leave no doubt as the conclusion does it go as a matter of law.
And here, Your Honor, the uncontested facts, they're uncontroverted. There's nothing for a trier of fact to determine.
Right, and you both cite the same facts, and you both say that the inferences lead you to obvious conclusions. The facts aren't disputed, but aren't there two different inferences that you're asking us to withdraw?
Absolutely not, Your Honor.
Okay.
Because if you look at June 12th, 2014, What are the uncontested facts that G&G knew about? It knew that Stone by Lynch was on the property. It knew when it was there. Look at the daily logs. And it knew what it was doing. Look at the daily logs provided by G&G's own representative on site. It also knew that the Lawsons were making claims as a result of Stone by Lynch's work. And the most important thing, Your Honor, on June 12, 2014, G&G knew that there was an insurance policy in place, had the policy number issued by Central Mutual, had the policy number, had the effective dates of that coverage, and had the name and contact information of Central's insurance agent that issued that COI. Everything that G&G needed to put Central on notice of that claim on June 12, 2014, uncontroverted, there's no inference, they had it. I am out of time, Your Honor.
Yes, you are.
Thank you, Your
I'll
Honor.
give you a little bit since we filibustered you.
Thank you, Your Honor.
May it please the court. I'd be remiss if I didn't get back to some of the questions that occurred earlier today as I sat through and listened to a prior argument, and that is the confines of the ICA's jurisdiction. Judge Greer summed it up as clear as I've ever heard anyone state it. When claims or parties are finalized, or words to that effect, I wrote it down as fast as I could. The appeal that Central Mutual has filed here, and tenacity is something that's important, I guess. And Mr. Schultz and his client have it here because they have chased up here as many times as they possibly could to try to bring this issue before the court or before the West Virginia Supreme Court of Appeals on a petition for a writ earlier. But there is no claim or party that is finalized by what is before the court on this appeal. This is simply a question of, were the claims of the Lawsons such that they triggered a duty to defend under the Central Mutual policy? That's it. It doesn't conclude the claim of whether there's liability, what the damages might be. It doesn't conclude any party. None of that's affected by this. Now, we're going to get to other things that do.
Given the other orders, is there anything still pending in the circuit court?
When we get to the next two, particularly the next one on the Central Mutual order that we've appealed, this seems to be a moot issue. What difference does it make? And that's part of our...
But is there still pending matters before the circuit court right now?
The only thing that is left before the court in light of the two other orders that'll come up here, number 2 and 3 here today, is Archetype, which is the Builders Mutual's insured, is down there subject to claims for its, as a subcontractor, indemnity obligation to G&G.
Okay.
So, again, interlocutory, not before the issues that are appealable to this court based on this one. But let's get to the gist of it here. This project started back in roughly 2011. Stone by Lynch began work on May 5, 2011. Its Central Mutual policy was relatively short for the period of time it was doing work, but it was the most important part of its work in light of what came to be known through the discovery in that case. Their policy was July 8 of 2010, July 8, 2011. So over 2 months of this work, when they're prepping everything to put this stone up, which is where they're putting up the waterproofing, where they then lay the stone against, that was determined to be faulty. Now, the civil action was filed. No good deed goes undone. I wasn't the attorney that brought this case. It was brought by Bo Sweeney at the Junkins firm in Huntington back in 2014 in March, as I recall. As a mechanics action, to perfect the mechanics lien, there was a dispute. G&G was owed $300,000 roughly for its services as the owner's representative. So it files a mechanics lien. If you go back and look at the history of mechanics liens and the construction trade, I don't have a crystal ball, but I don't need one to tell you what's going to happen every time. The property owner that doesn't want to pay or hasn't paid comes forward and says there's something wrong with the work or product that you've provided, because that's their defense. It's always going to be their defense, and that's what they brought here. So what happened over the next several years? Roughly 3.5. G&G, through its counsel, Bo Sweeney, was fighting about this is required to be arbitrated. There was a mechanics lien complaint filed. There was a counterclaim that made vague references, and they were vague references to defective work or incomplete work and things like that. So they sought to take it to arbitration. That went to the West Virginia Supreme Court of Appeals. You guys didn't exist back then yet, so didn't even have a chance to go through the intermediate court. So it goes up on appeal. The Supreme Court ultimately said, no, we're not going to require arbitration. So it goes back. Then discovery starts. The time frame for the notice to Central Mutual and to Stone by Lynch and dragging them into this case was based upon the discovery that was going on there in 2019. The expert disclosures, which were submitted in August of 19, the Bozo report was dated August 1/19, but he had been out to the property during the few months leading up to that. And everyone else was out there with their experts looking at it at the same time. My wife-in-law partner, Tanya Kessler, was out there. And in order to do some of the testing there and to get the opinions, they took down some of the stonework. And the water barriers were not placed in there, and you could take your finger and you could shove through the construction of that house. Now we got a problem, Houston. So Central Mutual was brought in. There was notice sent out. I believe it was in June. The notice letter went out dated June 21 of 2019 to Central Mutual from Tanya Kessler. They responded and acknowledged receipt of that on August 21 of 2019 and refused defense. Then they formally denied coverage, more detailed, July 31 of 2020. Now, in the meantime, Central Mutual, well, not Central Mutual, but someone defends Stone by Lynch. But no one is defending G&G with respect to the Stone-related claims, which were evident at that point.
Did that actually happen? Was there some aspect of the lawsuit against G&G that actually went undefended? Or was there attorneys that were representing him for everything? And although you allege that Central should have been in there paying for this defense, my question is, did some portion of that lawsuit actually go undefended?
No, because that's not the way the defense obligations for insurance exist in West Virginia. When that came back after the Supreme Court refused the arbitration request in the appeal, G&G had its insurance agent give notice. That's the first time they gave notice to anyone of their insurers. So Westfield Insurance Company got notice. Westfield's a CGL carrier. They don't provide coverage for G&G's work as an owner's representative, but the carrier that would have provided that was a separate carrier that was involved in this for a short time, an XL-related company that actually had a different name here. Westfield stepped in and provided defense under reservation. So they were never undefended. When this thing came back with the refusal arbitration, there was a defense. So there's no prejudice here. Counsel wants to argue that there's this predicate to coverage, which is notification of the case. But there's elements of that they don't want to talk about, which is there has to be prejudice.
Before we get to that, why is that a question for the jury? Because both of you are arguing that reasonableness should be resolved in your favor as a matter of law. The general rule, it's a question for the trier of fact. Why isn't that a question for the trier? He's explained the 5-year, you've explained the process. Why doesn't that go to a jury and let them sort it out?
Because I think the facts here were so clear, and Judge Howard, who lived through all this, we never went to a hearing that Judge Howard didn't tell us what the foot level was of how much filing was in this case and how much the clerk's office was complaining about it. He saw what was going on here. It literally was like peeling onions to determine on this $6 to $8 million house built in Milton, West Virginia, of all places, what all was wrong. There were issues about the paintwork by Noble and Family Painting, the stonework by Stone by Lynch, the drywall work by Archetype, the tile work by Payne Tile, and more and more and more. But you had to peel the layers of the onion. Marvin Master, exceptional attorney, but this complaint through his firm was very vague. The counterclaim. So you had to do discovery to figure out what the issues were and then go back and try to corral who did that work, who was the insurance carriers involved in that, and bring them into this. And what I think Judge Howard clearly reflected, and it's in his order granting summary judgment to G&G on the coverage. And again, remember, all he said was there was a duty to defend. That this triggered a duty to defend. He specifically set aside the issue of indemnification and whether there'd be a duty to indemnify because that was premature at that stage. So a duty to defend is readily adopted. Westfield, again, got this, and it was clear from their policy they don't provide coverage for work as a owner's representative. It's for negligent construction, things like that with collateral damage. But they defended under reservation. That's what your typical insurers do here. Central Mutual refused to do that. Even after the court ruled on the coverage, they refused to do that. So
Let me give you a chance. I know we're running out of time, but let me give you a chance to discuss Marlin. And your position, we don't even get to reasonableness because they can't rely on that provision because they didn't give conspicuous notice in the certificate of insurance. What misled G&G, or what did they detrimentally rely on in that certificate of insurance?
G&G was provided a certificate that indicated that Central Mutual provided the CGL, Commercial General Liability Policy, applicable at the time this project started with the work of Stone by Lynch. They reasonably relied on the fact that that coverage was there under a typical CGL policy. If there was a hoop that you need to jump through in order to be able to get that coverage,
Did they, is your argument they didn't provide notice because they didn't think they had to because it wasn't in the certificate of insurance?
is that there wasn't anything there that said, if you don't learn of the nature of our insured's role and tell us about a counterclaim within 1 year, 5 years, whatever, pick it. They want to pick a specific date. That's not what the law is.
Well, I know, but I mean, is it your position? Gosh, G&G, we would have provided notice way back there in 2014 if we'd only known we had to. I mean, is it your position that they had no idea they had to provide a potential liability insurer notice?
Provide a potential liability insurer for a subcontractor notice until you understood that that subcontractor's work was specifically.
Well, that's a different issue because if the notice provision is out, then it doesn't matter if they ever provided notice.
I'm not here arguing that it's not, I think, anyone in the commercial business. And G&G is not a naive insured or entity or in the contractor. They've been down this road before. You understand that if you want to be protected by someone, you need to give them notice.
So the real issue is the reasonableness of the notice.
Exactly.
Okay.
Fair
enough.
And what the court has said in Marlin versus Wetzel, they cite to the Brown machinery work case, and they say the whole issue of notice is whether or not the insurance company has been prejudiced in its ability to defend the case. Judge Howard found, no, the case has been defended all along. You know, there was a fire, I think, in 2015 involving Stone by Lynch and some of their records, but none of that impacted Central Mutual in any way different or more severe than what impacted G&G. I want to hit one thing from this whole thing about the notice anyway, because it's a red herring. The policy from Central Mutual, they keep saying you have to provide notice as soon as reasonably practicable. But what it actually says is we will defend, let me get to that piece. It says you must see that we are notified as soon as practicable of an occurrence of an offense which may result in a claim or in a suit. You is specifically defined by this policy. It's the named insured. That's Stone by Lynch. That's not G&G. And the other thing it says, and this is central to the defense obligation, if we defend an insured, and Stone by Lynch was entitled to defense, against a suit, and an indemnity of the insured is also named as a party, we will defend the indemnity unless, if these conditions are met. And every one of those conditions was met here. We were entitled to a defense. G&G wasn't insured, as counsel has acknowledged again here today. All he wants to say is they lost their ability to be an insured and to have that defense because they didn't give notice earlier.
Understand your case. Thank you. Mr. Schultz, you have a couple minutes. We're
Thank you, Your Honor.
way over.
First, Judge Greer, under West Virginia law, question, and I'm quoting from the Colonial Insurance case, question of whether an insurance company was notified within a reasonable period of time is generally a question of fact for the finder of fact, not always. And in fact, under the Traveler's Indemnity case from 2015, the court stated, absent a demonstration of reasonableness, the burden does not shift to the insurer to prove that it was prejudiced by the delayed notice. And the inquiry necessarily ends with the finding that coverage is precluded by the insured's failure to comply with the policy's noticed provision.
Counsel,
Generally, you're correct, Your Honor, but not always.
does the fact that the SBL switched insurance carriers in the middle of the project cause some confusion as to who insured SBL?
Absolutely not,
The
Your Honor.
point of the negligence?
Absolutely not.
Not at all?
It doesn't because, again, G&G had both of those certificates of insurance. They knew exactly what policies were in place when. And this is a great point when you talk about prejudice, because G&G doesn't care about when Stone by Lynch did what when. For Central, it's absolutely critical because it's only on the hook for any work by Stone by Lynch before July 8th, 2011. That's why it's so critical that this delayed notice led to G&G's own witnesses looking at their own daily logs said happened too long ago. I don't remember.
So
which is the exact purpose for a notice provision.
So what was the actual prejudice? Was Central required to pay more than what they should have, or, I mean, do you have
The prejudice is this, and the purpose, again, Your Honor, of a notice provision is to allow an insurance carrier to investigate while the events the claims are founded upon are fresh on the witnesses' minds. So critical for Central Mutual were, number one, what did Stone by Lynch do before July 8th, 2011? Mr. Kesner told you about how important that was, the work done by Stone by Lynch. But how much of it was done before July 8th, 2011? How much of it was done afterwards? How do we find that out? Two sources. Number one, we have the witnesses from G&G on site who testified, we don't remember, it happened too long ago.
But if that were important, wouldn't they have just denied coverage for Stone by Lynch because you said they weren't provided notice by Stone by Lynch?
Stone by Lynch, we didn't deny coverage. We never were presented with the demand for coverage.
I guess my point is, if it were truly prejudicial, wouldn't Central have denied coverage for Stone by Lynch when you said they never provided notice?
Right. Because Stone by Lynch never presented a notice to Central Mutual never denied coverage.
But
it was never given a notice.
But they actually ended up defending Stone by Lynch.
No, they did. Central Mutual did not. Cincinnati Insurance did.
But, okay, not defended, but they ended up contributing. So wouldn't they have totally said, no, we're not going to contribute any money because there was no notice provision?
Your Honor, that's irrelevant to the question of whether there's notice or not.
It's not irrelevant to notice, it's relevant to prejudice.
It's not relevant to prejudice because it's relevant to the second appeal, which is whether or not G&G can pursue its breach of contract and bad faith claims because G&G has been fully indemnified and Central contributed to that indemnification. That's where it's relevant. And in fact, the other portion where we could go to figure out what Stone by Lynch did before July 8th, 2011 would, of course, be Stone by Lynch's records, which it's uncontested were destroyed by a fire in February 2015. Had Central been given notice in June, and I told you he would try to recast the notice date, and he did. It's June 12th, 2014. Had we been given notice then, we could have gotten those records from Stone by Lynch. Instead, the delay in notice prejudiced Central because those records were destroyed.
The case will
Thank you,
be
Your Honor.
submitted. Thank you. And you can keep your seats. You don't have to swap seats. We're gonna proceed directly to the next case, which I'd ask the clerk to please call.
Next on the Rule 19 docket, G&G Builders, Inc. v. Central Mutual Insurance Company, number 24 ICA 441, an appeal from the Circuit Court of Cabell County.
May it please the court.
This is an appeal from an order from the Circuit Court of Cabell County related to what I'll refer to as the extra contractual claims, the breach of contract, bad faith UTPA claims brought by G&G against Central Mutual because Central Mutual refused defense and indemnity. The court relied,
Mr. Kestner, you want to reserve any time, or
yeah, I'll save
a couple minutes?
2 minutes. The circuit court relied entirely on the Soaring Eagle case, which is factually distinct from the matters at issue in this case. Number one, in Soaring Eagle, the owner of the development was Soaring Eagle, and it had a general contractor or owner's representative. In that case, that was Branch. And then there were a bunch of subs that did lots of different work. Under the contracts that existed there, and this is common throughout the country and certainly throughout work that's performed in West Virginia in the construction trade, these contractors and subcontractors and owners' representatives enter into contracts with each other. As the West Virginia Supreme Court of Appeals recognized in the Canopius case, Elk Run and Canopius, it is reasonable and it is within the public policy of this state to enforce agreements among those entities as to how they want to allocate the risk for insuring against loss or damage. So it's common for these entities to do that. So in the Soaring Eagle case, the owner required Branch by contract to defend and indemnify and hold it harmless and to have insurance that would stand in place to do those things, which they had with Travelers. But more important than that, it went on and said, for all the subcontractors that you use, and you don't do a project like this one in the Lawson matter or in that Soaring Eagle case out in the snowshoe project, you don't do that without lots of subs. So all the subs that you use, you're required to have contracts with that require them to defend and indemnify you and us, again, as the owner. So that's a ladder of protection. Now, why is it? Historically, the reason these agreements exist in the first place, as I mentioned earlier, we had issues related to the tile work, Payne Tile, paint work by Noble and Family Painting, stone work by Stone by Lynch, drywall work by Archetype. If the property owner or someone wants to complain that the drywall wasn't affixed properly and it fell over and it hit my child on the head, and I've got a bodily injury case, who should defend the drywall work? Should it be the owner of the property? Should it be the general contractor who had nothing to do with putting up the drywall, or should it be the people that put up the drywall? Well, these insurance contracts and these construction contracts are designed so that the work at issue, the product at issue, the provider of that is who defends that work and that product. So why would it be unreasonable for Stone by Lynch, directly or through its insurers, to defend the issues related to the stonework? Why would it be unreasonable to expect Archetype that did the drywall work and its insurer to defend the drywall work? Why should G&G be defending those? It didn't do those things. It wasn't involved in that. So in Soaring Eagle, Branch got those contracts with the subs. So when there were claims for the snowshoe project that this was defective or that was defective and those things need to be repaired, the owner submitted it to Branch and its insurer Travelers. They submitted it to all the subs that were involved in the work that was at issue. And those subs and their insurers, through the insurers, stepped up and they didn't only defend the owner, which in this case would be the Lawsons, but it also defended the owner's representative, general contractor, which was Branch. So both Branch and the owner were defended in the Soaring Eagle case. Just like in the State XREL, State Auto versus Stuckey case, and just like the Fisher case, in those liability contexts, the insureds in those matters were fully defended at all times, under reservation, but fully defended by the insurer involved in each instance. State Auto in one, and I think Fisher was State Auto as well, if I'm not mistaken. So they're fully defended. So those entities, which were fully defended, wanted to complain then afterwards, while I've been fully defended and I didn't pay anything toward the settlement, but I would like to have a bad faith UTPA case. And the Supreme Court said in those cases, no, they didn't breach the contract. They did what they promised to do, which was to defend you, and in fact, they indemnified you. That didn't happen here because we're Branch in this case. We weren't defended with respect to the stonework or with respect to the drywall work. Those two contractors ultimately refused to do it. Now, other subcontractors stepped up through their insurers, and they participated in G&G's defense with respect to the paint work and the tile work and other parts of work that were at issue. But they were defending under reservation. They were only going to defend and then indemnify with respect to their insured's particular work and product. So The insurance carrier for Payne Tile, by the way, which I think was Nationwide if I'm not mistaken, wasn't going to pay any indemnity or go to bat dealing with what's wrong with the stonework or what's wrong with the drywall work. That's what left the gap for G&G. Judge Greer asked the question, was there ever a period of time where they weren't defended? No. Westfield stepped up and defended initially, and then as we were able to start getting the subs involved through their insurers, which did not happen, by the way, until we had to file dispositive motions and get down there, and I think we argued 11 at the time. Maybe a couple of them settled right before the hearing where they agreed to step in and defend. But there were 11 motions filed that were set for hearing. I think 7 or 8 of them eventually went to argument before the court on these things. And the court found regularly every one of these subcontractors entered into a written contract where they agreed to defend and indemnify. That's an insured contract. Central Mutual doesn't dispute it's an insured contract here. So they had that obligation. So what's left for G&G? While G&G was defended, they weren't defended on the stone claim or the drywall claims. More important, they had to litigate and prosecute the claims for coverage and defense. Now, what was paid by any insurer for defense that participated for Payne Tile or Noble and Family Painting, that was defense cost only, not any cost associated with prosecuting the claims to get carriers to step up and defend G&G for their subcontractors' work, or the costs associated with pursuing recovery of those attorney fees. None of that. Those are expenses that G&G has paid, has incurred out of pocket. That's its losses. No other subcontractor's insurer is going to pay the cost of you prosecuting claims against another subcontractor's insurer to get these things stepped up.
Before we run out of time, isn't another distinction with Soaring Eagle? Did your client have to give up, contribute to the settlement?
$250,000. Again, I mentioned this whole show started with a mechanics lien because they were owed $300,000 and they were due $300,000 under the contract. It wasn't even a dispute other than the Lawsons didn't want to pay it because they said there was some defective work. So as part of the settlement of the Stone by Lynch claim, we went to mediation, multiple day thing with Don Odell, and Central Mutual set off in a corner of the auditorium where we were over there in, I think, the old courthouse, and didn't participate in any way until the end of the day where they came in and added $100,000. But that already was after the negotiations had proceeded to the point that G&G had to agree as a condition to get settlement of those Stone by Lynch claims to give up $250,000 of its mechanics lien. Now, that's consideration. The court got caught up in an argument, well, that wouldn't have been covered under the Central Mutual policy. No one's arguing that Central Mutual had an obligation to pay a mechanics lien. No. What we argued is you had a duty to defend and indemnify, and you didn't fully do that.
Does the fact that Central actually contributed the indemnity, does that change it from the facts of Soaring Eagle?
No. So what, if they'd have come in and offered $1 or $1 million or whatever, it doesn't change the fact that their insured had to contribute consideration to get a really short settlement.
I'm not asking from that perspective. So the fact, in Soaring Eagles, I understand the insurer that was sued there never contributed anything.
And
in this case, Central Mutual eventually paid some amount
Yeah.
towards the indemnity.
But-
does that distinguish it from Soaring Eagle or not? And that's a different argument than the 250.
It does, but in a different way. Travelers never contributed as the insurer for Branch, but the subcontractors did fully. They paid full indemnity. So in other words, the owner, which was then suing Travelers, never paid a penny of any money, no consideration of any type to the settlement of those claims. Now that's an important distinction because, as I described earlier in the Soaring Eagle case, Travelers was the mid-level, but their coverage was excess. As the court in the Soaring Eagle matter below noted, the indemnity that was provided there was provided consistent with the parties' agreement. Judge Tabbitt was a judge in that. And what the Soaring Eagle Supreme Court decision came out and said, according to the circuit court, petitioner, property owner, received a full defense and indemnity by the insurers to the subcontractors this was in quote marks, as envisioned by the parties as expressed in their contractual agreements. The coverage from Travelers there was excess. Travelers didn't deny coverage like Central Mutual did here. They said, we don't have a defense obligation yet. Our coverage is excess because the subs in that tier have endorsed their policies by typically additional insured automatic endorsement to make you, the owner, an additional insured, and they are defending you. That is the primary defense obligation. Here, Central Mutual is the primary defense obligation. They're not Travelers. They're the subs in the Soaring Eagle case that provided the actual defense. They want a free ride. I wrote a note, and I suspect I'm out of time here. I wrote a note.
Suspect properly.
Yeah. So here's what they asked to be. Race to be last. If you can avoid any responsibility at all, wouldn't it be in your interest as an insurance company to just refuse, and hope someone else steps up? Because if you never step up and someone else defends, you get to walk scot-free. That's what they're asking this court to do.
May it please the court, again, my name is Michael Schultz, and in this case, I represent the appellee, Central Mutual Insurance Company. In this appeal, Central asked that this court affirm the Circuit Court of Cabell County's order that granted summary judgment to Central Mutual on G&G's claims for breach of contract and statutory and common law bad faith. Importantly, if this court finds, pursuant to the first appeal, that there is no coverage for G&G under the Central Mutual policy because G&G failed to fulfill a condition precedent by giving timely notice, this court doesn't even have to address the substantive issues in this appeal, and instead can summarily dismiss those claims made by G&G for breach of contract and bad faith, because without coverage, those claims fail as a matter of law.
But don't we have to address this anyway because of the builder's case?
I'm sorry, because of the which case?
The builder's case.
It's not as clear.
In that appeal, correct, which is a separate appeal,
We
but
have to address this
not
no matter
as
what.
vis-a-vis Central Mutual. Correct, Your Honor. Now, there are two issues before this court. And it's amazing how little time Mr. Kesner spent on those two issues as raised by Soaring Eagle. Number one was G&G Builders defended without incurring costs under claims made by the Lawsons. He's conceded that G&G was. The second issue is whether G&G was indemnified for any payment made to resolve the underlying claims made by the Lawsons. That's the issue. Now, Mr. Kesner wants this court to focus upon the conduct or the failure to act of Central Mutual, but that's not the lesson of Soaring Eagle. And Soaring Eagle adopted in toto the order written by the trial court, which was the business court. And in that order, Judge Lawrenson, different Judge Lawrenson, stated, and I quote, "The court interprets Admiral and Stuckey to determine the actual loss to the insured party, not to dwell on arguments which were ultimately unsuccessful or abandoned. The question the Supreme Court directs the trial court to is whether the insured party was defended without incurring costs and was indemnified for any payment made to resolve the underlying claim." The West Virginia Supreme Court adopted that approach.
So was
The
the
focus is on,
$250,000 release of the mechanics lien, was that a payment towards settlement or was it not?
it was not.
Why not?
Because again, Your Honor, the focus is on indemnification. Central has a duty to indemnify, as every insurance company does when there is coverage. Indemnification means payment of monies to settle claims. Under the policy, Central, and I quote from the policy, "will pay sums that the insured becomes legally obligated to pay as damages because of bodily injury or property damage to which this insurance applies." The duty to...
If they'd have stroked a check for $250,000, would it have been different than releasing the mechanics lien for $250,000?
That would have been a gift. Because, Your Honor, consideration for a settlement agreement is a completely different analysis than payment pursuant to an indemnification obligation. Simply because G&G provided consideration in the form of partial release of a mechanics lien that was not, could not, and would never be part of the analysis about indemnification, that's just consideration that it added in order to get a settlement agreement, which is different than what Soren Eagle instructs this court to do, which is to look at the duty of indemnification and figure out if G&G was fully indemnified, i.e. all the payment of monies were made by somebody other than G&G to settle the claims.
You're saying even if they paid $250,000, we ignore that too?
How is that a
Because-
gift?
Because that payment isn't part of the indemnity obligation under the contract of the insurance companies. It'd be different if Central went to G&G and say, we demand that you pay $250,000. That's a problem. That's not what happened here. But giving that up is not part of the indemnification. And again,
So Central was denying coverage and denying any duty I mean, that was still disputed at this time.
that was still disputed,
Okay.
correct?
And so you're saying a potential insured in that situation, you're saying they can't ever settle, they just have to let lawsuit proceed and get to a judgment and then fully litigate and see whether they can get indemnified after the judgment, but they can never settle because that would just be a gift.
Your Honor, when there is only one insurance company involved, and that's the Admiral case, if there's just one insurance company involved, woe be to that insurance company if it decides not to defend and indemnify and allows those cases to go to trial. But if an insurance company continues to challenge either the duty to defend or indemnify while the insured has a full defense and is eventually fully indemnified, that's the Admiral case, where the case went all the way to trial.
We may just have a different disagreement here, but I'm struggling to see fully indemnified when if they make the decision to contribute to their settlement. I guess you're saying they don't have the right to do that if somebody's disputing coverage.
If G&G wants to contribute to the settlement over and above what is being demanded from the insurance companies, then yes, that's just a gift by the insured. Doesn't have to do it. That's a gift. And again, that's consideration.
Apparently they couldn't get a release without it. It wasn't, we'll give you a release from what the insurance companies pay, but if you want to give us an extra $250, we'll take it. That's not what happened. They kicked that in for the release, didn't they?
There's no indication, there's nothing in the record to say that, Your Honor.
Okay.
But they were, I mean, the reason why they were sued initially was because they weren't paid, correct?
The reason why who was sued?
The G&G. The reason why G&G was not.
G&G was sued by the counterclaim from the lawsuits for damages
The
to
reason
the
why
home.
G&G sued the Lawson or whoever they are initially was because they didn't get paid by the Lawsons, correct?
G&G claimed that there was a mechanics lien on the home.
But the reason why you file a mechanics lien is because you don't get paid. Is that not correct?
G&G claims that they provided services or materials that were subject to a mechanics lien.
You don't file a mechanics lien unless you don't get paid for work.
Those were the allegations, correct?
So if they're not getting paid the money that they were owed under that contract, how is that not consideration? I mean, it's not a gift. They're saying it's not a gift. They're not getting paid money that they were due under that contract. Are you saying the contract's not valid?
It's consideration for a settlement agreement which has nothing to do with indemnification. And again, step back and ask who's the real party harmed here. And again, Judge Lawrenson in the business court, he got it absolutely right, and this is where this court's attention should be under Soaring Eagle. When Judge Lawrenson wrote, quote, if the other carriers, Cincinnati, Erie, Liberty Mutual, believe their policies were excess to travelers and wish to litigate that issue to recover their defense and indemnity payments, those issues would have to be resolved in a separate civil action. In other words, if insurance carriers disagree among themselves, it has no bearing on the fact that SEDC, the insured, was defended and fully indemnified throughout this case. If there is a party who should be complaining that it had to pay monies for indemnification to settle the Lawson's claims, that would be Cincinnati Insurance, and it can file a lawsuit against Central. If there are parties that are aggrieved by having to pay more than their fair share of defense costs, let them file that. But the fact is that G&G has been fully indemnified, G&G has been fully defended, and the only reason they want these bad faith claims to go forward, because the only damages that G&G has are Mr. Kesner's attorney's fees. Other than that, G&G has been fully indemnified under the insurance agreements. It's been fully defended, and that's what Soaring Eagle tells this court to look at. Thank you, Your Honor.
Understand your case.
I'll be very brief, but
He's got 2 minutes.
I don't recall, unfortunately, the name of the case, but it was in our briefing before the circuit court, and I suspect probably our briefing here. An insured who's been denied a defense by an insurance carrier is permitted to protect itself by stepping in and settling. And while there was defense for G&G for various matters related to other subcontractors' work and product, that was not true with respect to the Central Mutual part. Cincinnati was involved, but yeah, the dates are important because Cincinnati's policy didn't start until after the Central Mutual one expired on July 8, 2011. A lot of the important work related to that waterproofing was all done before they were involved. They're not going to step in and defend or indemnify G&G or anyone else, or even Stone by Lynch for that matter, with respect to things that occurred before their policy inception date. So it's a gift if you give up something that you have a contractual right to receive, which was the payments due the owner's representative, and they filed a mechanics lien and had to, under the statute, file suit within a time period in order to perfect that. That was not a gift. It was a condition of the written settlement agreement that they had to do that. And Central Mutual throughout this entire case, on their duff, sat in the back of the room during that mediation and did nothing, did not participate in the discussions or anything until the end of the day after that condition was already there, demanded and met by G&G, where they simply added at the end to push it over the top $100,000. That did not save G&G from its consideration. So what is at issue? It is, as I mentioned earlier, even with defense that's been provided, that didn't cover in any way all the time and expenses for attorney fees and otherwise that G&G incurred prosecuting the claims to get Central Mutual, Builders Mutual, to step up and do what they were required to do under the contract. They don't even dispute that G&G is an insured, but they do want you to go back and take up the interlocutory matter because they're so convinced that Soaring Eagle clearly, on the facts, isn't this case, that they don't want you to get to this Soaring Eagle appeal. They want you to try to find some rule, ignore the general rule, but just if it's 5 years on notice, regardless of the facts or circumstances, then you're just precluded. Even when G&G was never told that there's some magical date, it has to be within 6 months or 12 months or whatever. What's the date by which you have to give notice? It's reasonable under the circumstances. That's the standard.
Thank you. We understand your case, and it'll be submitted. Thank you.
All rise, remain standing while the judges leave the room. Court will recess until 12:15.
It's like a minute for them.
Not very long.
Judge, how you doing?
And be silent. This court is again in session. Please be seated.
Clerk will call the next case.
Last on the Rule 19 docket, G&G Builders, Inc., v. Builders Premier Mutual Insurance Company, number 25 ICA 42, an appeal from the Circuit Court of Cabell County.
You again?
It's
Mr.
like-
Kestner,
it's
it
like-
doesn't make sense to try to reserve time because we're not going to pay any attention to it. But I'll give you 2 minutes at the end of
It's
the
like,
deal.
correct, just to stand up here and wave or something, yes. Yes, I've talked about the fact that this is not Stone by Lynch. I'll just adopt by reference my arguments in that regard from the earlier presentation because it's exactly the same here. I'll hit just a few of the additional points perhaps that I didn't get to before. For the drywall work that was at issue, it's supposed to be a level 5 drywall finish. The Lawsons complained that it wasn't a level 5, that it had weaves in it because they didn't put in expansion joints, things like that. So who should be defending that? I talked about the historic basis for these indemnity agreements and for the insurance policies that are written to pick them up. I mean, you can trust me, insurance companies don't run out here looking to do gifts where they're just going to give free coverage for something or pick up risks that they shouldn't or don't want to pick up. Why did they pick it up? Because if I'm the insurance carrier for Archetype, the drywall contractor, and there's a claim against my insured and an additional insured related to the drywall, it's reasonable for me to pick that up. I'm defending the drywall. That's what is at issue, and that's what was at issue here. The Lawsons complained about drywall. Drywall was made a part of the case. Builders Mutual was the insurer for that. Now, their policy has what is often referred to as an automatic additional insured endorsement. What it says is that added to the definition of insured is any person or organization other than an architect, engineer, surveyor, G&G's none of those things, which requires in a work contract that such person or organization be made and insured under this policy. That's G&G. Central Mutual didn't dispute that G&G was an additional insured. Builders Mutual does, because they wrote their policy down in North Carolina. So in North Carolina, these contracts between contractors and generals and subs and things like that, that would require a sub to step in and indemnify, defend, and hold harmless a general contractor, as an example, violate the public policy of the state of North Carolina. Well, that's expressly not the public policy of this state, which has adopted in Marlin and the Canopius case and recognized repeatedly that it is within the public policy of this state to enforce these types of agreements that are freely made by and between the parties, because it assists the parties in corralling and assigning the cost for obtaining insurance for these risks and the prompt and fair resolution and settlement of claims and cases, which is what courts generally love to see happen. Prompt. This case is far from prompt. Unfortunately, something went off the rails on this one, and what was that? Well, it had something to do with the fact that the drywall people didn't want to defend the drywall. When Archetype got brought into the case, they defended their insured, but they ignored their additional insured. Throughout the briefing in this case, they continue to argue that G&G was defended throughout. They never participated in G&G's defense. And while G&G had the benefit eventually of defense through litigation and summary judgment motions, through other subcontractors, insurers, for those subcontractors' work and product defects, like the paint and the tile work and things like that, that never happened with the drywall. G&G went through the mediations, and in fact, this piece was the last part of the Lawson's case that was resolved. It didn't settle, as I recall, at the mediation. It resolved afterward. So G&G was facing going to trial, defending itself then on the drywall work, because everything else was concluded in the case. And still, Builders Mutual would not agree to meet its obligation. After the circuit court's ruling that they had an obligation for defense, but indemnity was held, but for defense they had the obligation, they wouldn't do it. They wouldn't do it. So notice in this case was provided as soon as the drywall issues came up. So why don't we have the notice issue here the way we just heard it in the Central Mutual one earlier here two ago? Well, maybe it's because in the complaint, or the counterclaim actually here, the Lawson's counterclaim didn't say anything about drywall. It referenced certain specific things, and then it said, and other defects. That had to be hashed out through discovery. It wasn't until discovery responses were obtained and then pursued for clarification that they indicated, oh yeah, and the drywall is wavy and is defective in terms of what was supposed to be there with a level 5 finish for drywall. So when that happened, Archetype was joined to the case, Builders was joined to the case. They refused defense and indemnity. They continued to do that. They continued to this day to do it. They want, just like Central Mutual wants, a soaring eagle pass. I mentioned earlier, race to be last. They want to be someone that benefits from the fact that other subs for their insured's work and product stepped in and defended so that they can avoid any obligation.
I'm maybe confused on the facts. On page 12 and 13 of their brief, and I'm seeking this for clarification because maybe I just misunderstand. Builders response they're saying that they eventually indemnified the claim by paying for a release of both Archetype and G&G. Are you disagreeing with that, or that's what they're asserting in their brief?
Okay. They did not defend at any time, and the negotiations proceeded and were unsuccessful at mediation. Discussions between Marvin Masters' office, I think it was Kim Dotson over there that was running the file at that office, continued with counsel for, I think that was Van Valkenburg, Jeff Van Valkenburg. They eventually reached an agreement for settlement. When they did that, Builders, which would have been funding those discussions, because again, they were defending their insured, they required the Lawsons to include G&G, which the Lawsons were certainly happy to do. No one disputed that G&G didn't put up the drywall. They didn't tell anyone how to put up the drywall. They didn't provide the drywall. Not involved in it. They were just the owner's representative. So in the release that they paid $40,000 for, I think, it might have been 50, but it was $40,000 or $50,000 that they paid for, they had the Lawsons include G&G as a release entity. No defense up to that point, and that doesn't address at all under Petrollo the attorney fees and expenses that were incurred in pursuing them to defend and indemnify.
In that section where they say Builders retained attorneys to actively defend the defective drywall claim, I'm assuming then that they employed attorneys to defend Archetype.
Jeff Van Valkenburg and his firm, which is Varner and Van Valkenburg out of Clarksburg, defended Archetype.
And they did not.
They never defended G&G.
Okay.
I'm sure Jeff Van Valkenburg will be the first one to tell you that he's actually adverse to us because we pursued claims against Archetype too, because its initial contract with G&G requires them to hold us harmless. Now, typically they would do that through insurance, but their insurance carrier was denying, has continued to deny the obligation. So Archetype is still involved. You all asked what's left back in circuit court. That's it. Archetype is still back there waiting to see if its insurer is ever going to actually step up and take care of what its obligations were. I do want to address Petrollo. When an insured is required to retain counsel because the insurer has refused to defend in violation of its insurance policy, the insured's entitled to recover from the insurer the expenses of the litigation, including costs and reasonable attorney fees. That includes the cost to compel their compliance with their contractual obligation. That's what G&G has incurred here that we are pursuing, is what did it cost us to get them to the table to defend, to participate, and to ultimately indemnify, which they did. So they refused to agree that G&G is an insured, but they stuck G&G on that release effectively as an insured when they paid for Archetype at the end. Archetype got a defense, we didn't.
Has G&G released its claims for attorney's fees against Archetype?
No. No, like I said, that's what's left back there. But that becomes moot if Central Mutual, Builders Mutual, too many mutuals here. If Builders Mutual is required to comply with its contractual obligations to have defended and to indemnify and to step up and pay those costs because G&G substantially prevailed on that coverage issue for defense, then, you know, you don't get that money twice.
Okay, so you're admitting that you don't get a double recovery on that?
Oh, absolutely. And that's been clear in all my communications, discussions with Jeff Van Valkenburg, is if the insurer steps up and takes care of this, as you would expect through the contractual arrangements would be done, then the insured is protected. That's what they got the insurance for in the first place, and why they had G&G made as an additional insured under this automatic additional insured endorsement. Thank you. Any other questions?
You got 2 minutes after respondent.
May it please the court, Gus Sains, here on behalf of the appellee, Builders Premier Insurance Company. I've got a chance to listen to the story, if you will, that was told regarding this case and how everything fits together. Well, it doesn't fit together like that. First of all, there was no counterclaim by the Lawsons for drywall work. And the case proceeded for, 3 or 4 years before finally the Lawsons made a direct claim against G&G for the drywall work. That was defended immediately by another law firm on behalf of Builders. And that was continued to be defended throughout the litigation. G&G had and is out absolutely no defense costs, fees, which are undisputed, or anything else related to the defense of the drywall claims. The drywall claims, which were $11,000.
You're saying Builders did provide G&G a defense for the drywall?
It provided a defense to the drywall claims first made by the Lawsons.
Against who?
Against Archetype.
Okay, well, that's not, we're not here talking about Archetype, we're here talking about G&G. Did Builders ever provide a defense to G&G?
Directly? No, sir.
Okay, thank you.
G&G had been defended throughout the case. The thing about Soaring Eagle, Your Honors, is that it clearly indicates that it doesn't matter where the money came from in terms of the indemnity and the defense. It doesn't matter. They've been clear.
You know what's absolutely clear about Soaring Eagle? It's a memorandum decision. I mean, the Supreme Court wasn't intending to make groundbreaking law on Soaring Eagle. But one of my struggles here is, I mean, we're being told all these grandiose things Soaring Eagle did. Supreme Court didn't intend to make law with Soaring Eagle.
Your Honor, as it cited Fisher and Stuckey, relying on those two decisions in making their memorandum decision in Soaring Eagle, it didn't just rely on the facts in front of it, if you will, and new law. It applied Stuckey and Fisher, as noted in the opinion. And in this case, it's even a better situation for an affirmation of the circuit court's opinion, indicating that there is no and cannot be any bad faith claims. In Soaring Eagle, there was a tender of defense to travelers. In this case, unlike Central, G&G never tendered a defense to Builders at any time and sued them in April of 2021 under bad faith causes of action, not a declaratory judgment action, bad faith causes of action. It sued Archetype in April of 2021 for the first time for attorney's fees related to the defense of all of their claims that were being made by the Lawsons against all of the other subs, contractors, and you name it. There was never a declaratory judgment action filed. There was never a declaratory judgment action initiated by G&G to establish coverage by Builders. And the reason is, Builders, this policy that Builders had with Archetype, as set forth in undisputed affidavits that were submitted in the circuit court, both on jurisdiction, on coverage, and also with respect to the summary judgment motion on the bad faith issues was Builders is a North Carolina insured. Builders does not write business in West Virginia, much like G&G indicated that it needed when Archetype signed a contract with the Lawsons for the drywall work back in 2011. The certificate of insurance issued by an agent for Builders did not name G&G an additional insured. In fact, there was no knowledge on behalf of Builders that Archetype was even working in West Virginia, because all of the risks that were insured, all of them, were a CGL policy issued in North Carolina to a North Carolina corporation that was not doing business in West Virginia and did not indicate that they were working in West Virginia and needed a certificate of insurance naming G&G or the Lawsons as additional insured. It just never happened.
Did you appeal that issue?
Pardon me?
Did you appeal that issue?
We did not appeal that issue because first of all, the decision from the court regarding indemnity and coverage was in 2022 from the bench, and there was no order entered until late, I think, April of 2024. In the meantime, we realized that there was no bad faith claims that could be asserted in the case, and filed our motion for summary judgment on that issue, because that would end the litigation with respect to Builders.
Right, so that issue is not really relevant to us, right?
It's not relevant right this second, Judge, but as counsel has indicated, much like a lot of these things, really this issue is interlocutory, given the fact that Archetype, Builders insured, who they're still defending and paying for defense for, is on the line for attorney's fees, which is another issue. So
The claims of G&G are gone.
G&G, Your Honor.
Against the insurance companies, they are. And they may have something against Archetype, but as to the claims against parties, they're gone, right?
Correct, Judge.
Okay. Well,
Correct, Judge.
that's
Yes.
where we need to be.
Yeah, that's absolutely correct. And like I said, it's a stronger case in this matter because there was no tender of defense.
In Soaring Eagle, the insurance company, there's too many insurance companies, so I can't remember the insurance company that got sued in Soaring Eagle. Maybe it was Travelers.
Travelers.
I don't know. How about that? I guessed it right. Okay. Travelers never contributed anything to anything, correct?
Correct.
Okay. In this case, for whatever reason, I mean, your client paid $40,000 and they got a release for G&G.
That's correct, Your Honor.
Why does that not take that to more of hayseeds, Petrello, whatever, where we're in the land where a potential insured has to institute litigation and ultimately get something, and then maybe they're entitled their attorney's fees? Why should we be guided by Soaring Eagle and not Petrollo hayseed?
With respect to Petrollo, Judge, a deck action was not filed in this case. As I noted, the first claims against Builders, and it was odd, quite frankly, because G&G had filed declaratory judgment actions against Greenwich and a bunch of other carriers, setting forth the basis for their understanding of why coverage was owed and/or a defense. In this case, no such declaratory judgment action was taken. Builders was sued for the first time in January of 21, and by 11/21, the plaintiff was G&G was pursuing summary judgment on the issue of coverage without a declaratory judgment action being filed. Petrollo talks about having to file a declaratory judgment action and there being reasonable attorney's fees that could be obtained as a result of having to do so. In this case, a declaratory judgment action wasn't filed. The second part of Petrollo and why it doesn't apply is that the insured, if you will, in this case, or putative insured, G&G, would have had to make the claim for insurance coverage. They never tendered to defense to G&G, to Builders before they filed suit for bad faith in April of 21. And the insurance company disputes that without reasonable justification. In this case, Builders had a reasonable justification, Judge. It didn't even know this lawsuit was occurring. And on top of that, did not know that Archetype, it's insured under the CGL policy in North Carolina, was even working in West Virginia. There was no additional insured named, either in a certificate of insurance or in the policy itself. And they had no idea that it was going on because they had not been tendered a defense. Archetype had been sued, and they retained counsel to buy the Lawsons in 2019 and retained counsel to defend the drywall claims. The drywall claims were, as counsel said, pretty far down on the list, although in his initial argument indicated they were with Stone by Lynch with the drywall, or excuse me, the proofing and the stone, and you could put your hand through it. Well, I got to tell you, the Archetype claim was made by not G&G, but by the Lawsons, and the Lawsons are the only one that put a number on what the damage was, which was a little over $11,000. And that was in their pretrial memorandum after the case with respect to the drywall had been defended. Ultimately, Builders paid indemnity of $40,000 and obtained a release on the part of both Archetype and G&G, and their defense costs, not necessarily for G&G, but for Archetype.
Well, not necessarily, it wasn't for G&G.
Right, was paid and continues to be paid, and Archetype continues to be on the line as Builders is representing them on the attorney's fees that were not asked with respect to Builders, but were asked for with respect to Archetype in the claim made in in April of 21. And the interesting thing is that the G&G filed a motion for pro rata attorney's fees. We all know, and G&G admits, that all of their defense costs have been paid. There's nothing out of pocket. And all of the indemnity has been paid. They filed a motion for pro rata attorney's fees against Archetype. They wanted their pro rata along with all of the other insurance companies that agreed to pay a pro rata share. They weren't obligated to assert that claim against anyone. All of the other insurance companies involved had agreed to pay pro rata share, and there was no obligation on behalf of G&G to obtain any more money from any other source. But in any event, the court denied that. But the court indicated back in November of 24 that G&G should come back with the attorney's fees that it's out. G&G has not. And it like as was noted, it's still pending. So as we suggested early on, this is certainly Soaring Eagle, but it's really the facts are even more supportive of an affirmation of the Cabell County Circuit Court's order dismissing the bad faith claims, because in that case, Travelers paid nothing. Travelers didn't defend any claim. Travelers didn't pay any indemnity. Travelers didn't do anything. All of the other insurers did. And even in that situation,
Didn't that at least part because they were excess and they weren't really up to bat?
Your Honor, it didn't really seem to matter to the Supreme Court when it issued its opinion.
Because they issued a memorandum decision where they didn't really get into depth a whole lot, did they?
They got into the depth as suggested by citing to previous law regarding the issue of not only Petrola and hayseeds, which is the Fisher case discussed, as did the court in vis-a-vis Soaring Eagle, and as well the Stuckey case that discusses the issue concerning the defense costs and whether or not any bad faith claims can proceed under those circumstances. And like I said, it is a better situation in this case in that Builders did defend at least the the drywall company and the drywall claims in a case where it did not feel that it had any coverage based on issues that were not raised by way of a declaratory judgment action.
I don't understand how, you keep going back to that, and I'm understanding how that's relevant to the case regarding G&G that you all defended Archetype. Why, you've said that 3 or 4 times. Why is that important to us that you all defended Archetype?
Because G&G virtually had no defense with respect to the drywall claims, Judge. The drywall claims were not made by the Lawsons directly against G&G by way of their counterclaim. They sued Archetype in September of 19 for their own claim against Archetype for the drywall work they believed to be defective. The initial counterclaim from the Lawsons did not include Archetype. It did not include drywall. There was discovery later on in 2017 that indicated that the drywall was wavy. But there was no direct claim against.
But that became a part of the claim against G&G eventually in the Lawson's lawsuit against G&G. Are you disputing that? You saying it was never part of that lawsuit?
I'm not sure that it was, Judge. I know that mediation took place in which, both Archetype was present as well as builders on a couple of different occasions, and not sure whether anything was really talked about with respect to the drywall claims, nor do I know specifically, other than the discovery that was done in 2017, 2 years before anybody did anything with Archetype, concerning that there was a wavy drywall. But that's the sum and substance of the drywall claim, whether against G&G or whether against Archetype.
Do you have anything else you'd like to add?
No, sir.
Thank you, sir.
Couple dates that I think are important, and I'll refer you to the joint appendix at 237 and 238 and 266. The Lawsons answered discovery in April of 2017. Now, that date's important. That's 2017. They responded to discovery in respect to, or with respect to, their claims against G&G. In it, they list the things that were defective. Again, I mentioned in their counterclaim described defects mostly in a general way, but there were a few specifics they referenced. Drywall wasn't one of them. But in that discovery, they now mention drywall, which is wavy. So that's in 2017. G&G joined Archetype to the case in November of 2019. So that's around the same time that the Lawsons are joining Archetype, because the drywall's now been identified. Everyone's worked their way down to the $40,000, $50,000 worth of drywall work, as opposed to the millions of dollars of stonework and other things that were at issue in that house. Builders Mutual wasn't joined until April 2021. Now, why would that be? Because it's a year and a half after G&G joins Archetype. It's because we didn't have the certificate of insurance, couldn't find it. There are tens of thousands of pieces of paper, more than that now in my office, dealing with this, and couldn't find the certificate of service. Had to get into the discovery. But notification of a claim under the West Virginia insurance regulations and West Virginia law is any communication which reasonably apprises an insurer of a claim for which coverage or defense may be implicated under your policy. So when your insured was joined by the Lawsons and by G&G, and it's clear that drywall is the issue for your drywall company, then the general contractor that's also being sued, that's notification of that claim. It was necessary for G&G to go ahead and formally join Builders Mutual because they would not agree and did not agree to step up and defend that, despite the fact that their insured was in. They knew of the case, they knew of the claims, and they defended their insured, but would never agree to defend G&G. So the court, if you look at the Soaring Eagle case, and I suspect you've all seen it at some point, you'll get to look at it a lot more based on these three, I'm sure, but you will find in there specifically where the Supreme Court of Appeals noted Travelers never denied coverage. They indicated their coverage was excess, the primary coverage was with the subs, and the subs defended. That is not the case here. We don't have a carrier in the middle. It's the subs that had the primary coverage. And this sub, with its insurer, did not step up to meet its obligation. Coverage issues where the circuit court reached rulings, and I thought I was having a pretty good day. I got coverage for defense here and coverage for defense there. It's like getting invited to the prom and you've got a prom date. Wonderful news. And then you find out from the circuit judge that your prom date's your cousin. Not so good. So yeah, we thought we were on the top of the hill, and then in two different orders based on Soaring Eagle, not so great. We're asking the court to reverse the two orders based on the Soaring Eagle memorandum opinion, send this thing back to the circuit court to allow the claims against the insurers to proceed on the breach of contract, UTPA, and bad faith claims.
Two brief questions. Number one, just to be clear, there's two different types of attorney, I'm calling them two different types of attorney's fees. I want to make sure I have this straight in my own mind that you're claiming. One would be you're claiming that where these insurers didn't step in to defend G&G on the underlying claims of Lawson's, you should be entitled to attorney's fees under their insurance contracts, correct?
And Petrollo says that, said even if there's another avenue that you've taken by way of contract or otherwise that's independent of that obligation of Central Mutual or Builders Mutual here, those carriers don't get to benefit from that under the Petrollo case, because the court said better for that to be paid due to their obligation to meet it, and you get paid twice. But it's not paid twice. They keep arguing
Well,
that.
you're going past my question, so I'm
Okay,
going to cut you
I'm
off.
sorry.
Second question is, the second item of attorney's fees would be, you're seeking attorney's fees that you say your client had to incur to force these insurance companies to live up to their obligation. It's a separate type of attorney's fees, correct?
Correct, and that's Petrollo as well. Yeah.
What do you do with his, what's your response? Well, technically you don't get Petrollo because you didn't file a deck action.
There's nothing in Petrollo that says you have to file a deck action. I don't think Petrollo dealt with a deck action. It dealt with a breach of contract case. It's been recognized by courts that a breach of contract claim and a declaratory action in the context of insurance is the same. You denied defense or refused defense, I could file a request to the court to rule as a matter of law whether there's coverage or not, or I can simply file suit. You have a duty to defend. That's a contractual obligation. You haven't met it. That's a breach of contract. Isn't that all the same facts and the same elements?
We understand your case. It'll be submitted. Thank you.
Your Honor, I realize that this is out of date, but out of rule.
It is.
But, with respect to the first suit against Archetype by G&G in November of 21, as referenced by counsel for G&G, that did not include any kind of complaint for attorney's fees for anybody to defend them. It was just a standard indemnity. If the drywall is bad.
We understand your case. I appreciate it.
Please rise and remain standing while the judges leave.